Hi, Kevin. Can I just get your last name so I know which case you're here for? Hey, Milo.
Good morning.
How are you?
I'm well.
Good. Hey, Milo. Hi, Ed.
Good morning. Good morning.
We're still waiting for Deb.
Good.
Amy, have you heard from her today?
No, I have not. And she has my number, so she could text. She could have texted me if there's something was going on.
Okay.
So I assume she will be here. Right now, Melody and I are trying to figure out why the chat function is not working.
Thank you, because I was trying to do that.
No, it's not you. It's us. Somehow it got turned off and we're trying to figure out how to turn it on.
Yeah, it's not in the toolbar.
No, it's not even in. We're trying to figure out why it's not on, and also how to turn it on once you're already in a meeting.
Once you're in a meeting, yeah. In the security tab,
Yeah,
you can, yeah, you guys know more than I do.
yeah. I wish it was there, but I don't see it. We've looked at all the things so far.
Yeah.
We've tapped all the buttons. And we've looked back at the account view, so we're working on it. Hi, Betty. Nope, we can't hear you yet.
Mute. How's
Yep,
that?
that's good. How are you?
I'm fine. How are you?
I'm good. I'm going to keep you on mute just for now.
Okay, that's good.
And just FYI, we're trying to figure out why our chat function is not working in case you're trying to use it. That's not you, it's us.
Hello.
Hello?
Hello.
Yes, hi.
Finally, I got it.
Oh, is that Mr. Cloran?
It is.
I probably pronounced your name wrong and I apologize about that.
No, you did it perfectly.
Okay, great. I'm gonna keep everyone on mute for now, just FYI.
Yeah.
All right, I'm gonna try logging out and we're gonna see if Melody, who's a co-host, can enable chat function. I'll be right back. Don't panic. I'm back and Melody fixed the chat function. Go Melody. Good job.
Thanks.
So not that I think I need it, Amy, but I don't see the chat appearing in my,
You don't see the chat if you hit the chat bottom at the box? I mean, the chat function at the bottom?
yeah, it doesn't appear to click on it in the toolbar. Maybe we have to go in and out.
I don't even have a chat button showing up on mine.
That's what I
Oh.
mean. It's
Yeah,
not,
I don't either.
It's not, not in the toolbar to.
I think
open
if you
it.
click on Amy's face, it will give you the option to maybe send her a message. Or in the dots next to her tile.
If you click up in the right-hand corner, if you,
Yeah.
on someone, does it offer you chat up there?
No,
I think you can only chat with Amy, maybe.
No, it doesn't. I mean,
doesn't
the
offer.
dots, the dots offer you to pin the video to the
Right.
screen.
When I click on Amy's face, it lets me, just the picture, it says chat.
But that may be because you were able to enable it. It may be that other people, in order to use the chat function, they might have to log out and then back in like I just had to.
I'm not sure, but you can click on Amy's face on mine and I can send Amy a message.
I can't do that.
You're a co-host, so that would
Yeah, I
be a
think,
difference there.
yeah, I think maybe other folks, I apologize. If you want to be able to use the chat function, you may need to log out of this and log back in.
Let me just check the settings. I think I enabled everything, but let me just go back in real quick.
And Melanie, I also note under the participants list, which does open, there's a symbol for Melanie and for Human Rights Commission, which is Amy. That is, I'm not familiar with a little dot and a thing. Maybe that's indicating who the hosts are. I'm not
Amy
sure.
hasn't renamed herself again yet.
Yeah, but I will.
She's a little confused about her identity. And
I have identity issues for sure. So I recommend for folks, sorry for the inconvenience, but just to be sure, if you want to be able to use the chat function, take 2 seconds, leave the meeting and log back in. And I'm going to try to assign this to Mr. Mishral.
Can you hear me, Amy?
Yes, I can. Is that Miss Casey?
Yes, ma'am.
Okay, well, so I'm getting one message that says that someone left and tried to come back in and the chat was still disabled.
Was not me.
No, it was,
I was able to, I logged out and got back in and I now have the chat function.
I do not have chat.
I logged out and logged back in and I do have it.
You do. I'll try again. Nope, still disabled. No chat.
Okay, I had the icon, but when I clicked on it, it does say chat disabled.
and Mine does say chat disabled as well.
So we may not use it this session.
I just checked all the settings and it says it's enabled for everybody, but
Oh,
I didn't exactly tell it, nobody was it. I don't understand. Oh, wait, Amy, under security, allow participants to chat was unchecked just on this screen here. I don't know why. I
Mine
changed.
just came up on chat.
Yeah, I
Oh.
just, there's a toggle on this screen. This is not where I went to fix the settings, but I just noticed it on the screen, the front screen, that there's a little thing under security that was not checked off. So maybe that was the second piece that needed to be fixed. You guys are all set now.
No, I don't have video.
I have chat now.
yep.
Hi, little boy.
Good morning, everybody. It's 8:32, so I'd like to call the meeting to order. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, whether it's a cell phone or a pager, to make sure that they're silenced now. I've just done that myself. Everybody should have a copy of the agenda and the consent agenda. If not, you can find it online on our website at the link. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time period, and the commission has voted on those cases and they'll not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Before we get to the cases on the agenda, we'd like to conduct the business portion of this meeting. So can I ask for a motion to adopt the agenda and consent agenda?
So moved.
Second.
All in favor? Let's commissioners raise our hands so Amy can take our roll. Thank you.
Thank you. It's 3-0. The agenda and consent agenda are adopted.
Is there a motion to approve the September 14, 2020 commission meeting minutes?
So moved.
Second.
Commissioners, all in favor? Raise your hand. Motion
Thank you.
passes.
Thank you.
3-0. Amy, could we have a director's report, please?
Yes, yes. The director's report is for administration. We have, you don't have a written personnel report from me, which is mostly because I was out of town last week. We did have one staffer who had been out on leave for extended period, and they have decided to leave the commission. So we'll be talking about our options related to that position. You have, this is sort of mixed up, our usual monthly reporting and our quarterly reporting. So you have a few quarterly report items. One is the finance report, which you don't have a written report. Melody and I had just given you a report last month. So we're going to give you the finance and training and education reports next month. And I apologize for the confusion. For compliance, the status of pending reasonable grounds cases, there were, since the last meeting, 4 cases that are actively in the process of being conciliated. Since the last meeting, we had 1 successful conciliation in E19-0232 Foster versus Community Health. In a minute, I'll be asking you to approve. You have a memo regarding that conciliation agreement. There was 1 unsuccessful conciliation, Hodgkins versus Lambert. And so at this time, I'm going to, you have a memo, I think it's from me, regarding approving the successful conciliation in Foster versus Community Health. So at this time, I would ask that you make a motion to approve that conciliation agreement.
I move to approve the conciliation agreement in E19-0232.
Second.
All in favor? Raise your hand.
It's 3-0. Thank you. And who should I say is signing that one? It's usually the new guy. So Ed, how about you?
Sure. How do I do that?
You can give me authority to sign in your name, if that's okay.
Yes.
Okay.
So delegated.
Okay, thank you. I'm just gonna, because we don't have an interpreter here, our interpreter will be here soon. Oh, thank goodness, there's one. Okay. Okay. And we have not had ASL interpreters. Oh, there's, hi, Maura. Can you see Mr. Mishral? It says Kevin Mishral. We haven't done this process using ASL interpreters in this way. I'm hoping the interpreters, and we don't have our team here yet, will be able to tell us how this works for them.
And I just want to clarify, this is streaming on YouTube?
Yes.
Okay.
And we
I know
have,
that.
we have another interpreter team joining you,
Yes.
but they're not here yet. And so can you and Mr. Mistral see one another?
I can see Mr. Mistral and I can see the interpreter now. Yes, it's fine.
Okay,
The box has moved around.
Okay. I think, Mr. Mistral, if you want to pin the interpreter's box, that would let you see them all the time and maybe in a bigger picture. I'm sorry to interrupt the business meeting for this, but this is important to make sure everyone has access.
The interpreter's fine. I got the interpreter where I want them.
Okay, great. And we will be having a team join in a few minutes. Okay, so back to the business meeting. There is another conciliation matter. Oh, someone, I can hear myself twice and I certainly do not want to do that. I think, Maura, that might be on your screen, but I'm not sure. Okay, so going to, on conciliation, we do have one conciliated case in which the conciliation agreement was complete and actually has been fully implemented. So you have a recommendation from Barbara to dismiss the case. And I think there were some slightly extenuating circumstances with regard to the respondent going out of business. So if you feel ready after having read that memo to dismiss the case, I would ask you to make that motion now. If you think you need more discussion about it, we would take that during executive session. So I guess I'm asking the commissioners, this is with regard to E18-0132B regarding the Drouthy Bear.
No, I'm happy with the memo. I'm ready to make a motion to dismiss that based primarily on the fact that they're out of business.
Yeah.
And that seems
Yeah.
permanent. So I move to dismiss E18-0132, Mark Watt versus Drouthy Bear.
Yeah. Thank you. Is there a second?
Second.
All in favor?
So it's 3-0 and the case will be dismissed. So then moving on to investigation. And I just want to ask Jane O'Reilly, the other interpreter that's here for the very first case, that interpreter seems to be having some trouble joining. If you could possibly connect with them, maybe by email or phone, I would really appreciate it, because that's a case that we've tried to have that's been on our agenda. This will be the third time. So we definitely want to make sure we have everything we need to get that started right away. So back to investigation. Thank you, Jane. In September, we had 71 new complaints filed. For administrative dismissals, the report you have says 12, but we actually only administratively dismissed 5. The rest of them were right to sue requests or withdrawals without benefits. So not really sort of the involuntary administrative dismissal that I usually like to report on. For predetermination settlements, in September, we had 11 with benefits of just shy of $300,000 going to complainants. For pending inventory, at the end of September, we had 722 cases pending. So it's been pretty much there for the last several months. You do also have, in the resolutions report that you have, where I got the data about predetermination settlements, there's information that shows cases that closed in September, the average age of those cases was 373 days. And for fully investigated cases, it was longer than that. But as of now, as of the end of September, for all cases, the average age of a case is about 230 days. And for cases that are with an investigator right now, it's on average another 160 days. So I can't even tell if we're making progress right now, but it is fairly standard. For new business, the only things I would mention are that we are coming up to the legislative session. Since we have a biennial legislative system, we have 2-year sessions. We're starting the long year this year. It will be an entirely new legislature. All of the committees and their leaders will be new. So we'll be re-educating them once they're elected about what the commission does, and presenting budgets. The deadline for submitting biennial budgets is pretty much now. The deadline for submitting legislation, agency legislation, will be early December. The legislature is going to be convening on December 2nd, and we'll have to have our bill proposals in pretty much then. And we will be submitting bills. We don't have them in final form. One of them will be very similar to one that we submitted 2 years ago because it sat on the governor's desk and got kicked up and down several times. So that will be, a lot of the proposals in that will be resubmitted. And who knows, maybe some other things. We haven't even had a chance to really look at this, but we'll be starting now. Although I'm guessing Barbara's had a chance to look at it. I haven't had a chance to look at it. That's about it for now. Any questions about those items?
I would like to make sure we discuss those bills in executive session or whatever's appropriate, but the ones you're planning to submit again.
Yeah, that would be great. And we can, Barbara's considering whether we can discuss them in executive session, if I am interpreting the look on her face properly. Definitely we can discuss that in whatever setting is appropriate.
Thank you.
Sure. Anything else before we take the 30-second break that we have coming? Aban says he's waiting to be let into the meeting. I have hit the waiting button like 6 times. I mean, the join button. So maybe he should try again. That message was for Jane. Sorry. I have not had enough coffee to be able to message and manage all these participants and talk all at the same time. Mr. Kareem, we are waiting to get your interpreter in here.
Okay.
You are going to be first. This is your 3rd time. And Ms. Lamfer, we want you to go first, but we want to make sure we have the interpreter in here.
Okay. You have an interpreter right now? No. Oh.
He is on the line and he's trying to call in, and I have hit the button that says let him in, but it's not working. So, and yes, I see Mary McKay. Maura Nolan is on here and she is currently interpreting for Mr. Mishral. Can you see them? You're signing, so I think you're signing to Mr. Mishral.
No. Can you hear me?
I can hear you, yes.
Oh, okay. Okay. I'm not going to
see you
sign
and
then.
hear you.
Okay, great. No, I only see the main speaker and I've tried to adjust everything.
So I don't,
I only see whoever speaks.
okay, so you need to adjust the view. Can you look at the top left, sorry, the top right of your screen and adjust to, I don't know how to do that actually.
Yeah, it's not offering me gallery. It's only offering me full screen or exit full screen. And no matter which I do, I still only see you.
Which is a dream come true for everyone, I know.
Yes.
But somehow everybody else seems to be managing it. So I don't think that it is the meeting that is locked that way. Are you on a phone perhaps?
No, I'm on my laptop and I struggled getting in initially normally I just click Zoom, put in the information, and I'm into meetings. And today it was taking me here, there, and everywhere.
Huh.
I've been trying since 8:30, and
Oh,
I
my.
finally got in, and I don't even know how. So the only thing I can do maybe is log out and try again.
I'm really sorry, but do you mind trying that? Because I
No,
don't.
I don't. I don't
Okay.
mind, but because I need to see my participant and my
Yes,
the
indeed.
deaf person. Okay, I'll be back. I hope.
Okay, thank you. Mr. Bonds, hello. If you can unmute, we can't hear you. Can you hit the button that says mute?
Hello?
Yes,
Can you hear-
hello.
yes.
Hello.
Oh, sorry. So I was waiting. It didn't.
Yes.
Okay.
Don't worry, you're okay. The important thing is that you are here in time to connect with Mr. Kareem. Can you guys
Yes.
see each other? Mr. Kareem, can you see Mr. Bonds?
Alaikum.
I don't see him, as a matter of fact, Mr. Kareem.
Here. Hello. First one here. Kareem. Kareem.
Can you hear him?
Hello.
Very soft.
Can you adjust your speaker settings?
I hear you very well. I hear you perfectly. I mean, ma'am, I hear you perfectly. But still, I don't see him, and I don't hear him, as a matter of fact.
Can you see other pictures besides mine?
Yes.
Okay,
Yes.
so I can
Ms.
promise
Olivia,
you, he's
yes.
here because I can see him. Mr.
Ah.
Kareem, maybe if you talk louder, would your picture show up for him? I don't know. I'm not, yeah.
السلام عليكم.
السلام عليكم. أهلا مرحبا. أهلين مرحبا. أنا أبان المترجم. سمعني؟
اوكي اهلا وسهلا. انت تشوفني لو بس تسمعني؟
أنا أسمعك. نعم. أنا سمعانك.
انا دا اشوفك بس دا اشوفك ودا اسمعك.
ما عم تسمعني؟
لا انا دا اشوفك دا اراك ودا اسمعك.
خلاص. So he said that he sees me and hears me.
Excellent. And you can hear him.
Yes.
Okay, great. So now we're going to have hopefully our third interpreter, third language. We're waiting for the other ASL interpreter to come back.
Okay.
All right, so now we have Mary. Mary, can you see people other than me? I hope for your sake that you can. Thank you for laughing, Ted. I appreciate it. I think I'm hysterical, so.
Same situation, Amy. So I'll need Maura to voice to me when we're switching. And unfortunately, I don't see Mr. Maestro for visual feedback to know how to orchestrate my signing or the pace or.
Yeah, I wish I knew what to suggest, but I really do not.
Amy, can you hear me?
Yes. Hi, Maura.
On the bottom of my screen is a row of dots.
Yep.
If you click on those dots, it takes you to different windows that shows you different people. She may have the same thing on hers.
Mine says when I click on the dots, there's 3 dots and it says more. When I click on them, it says disable video receiving.
Nope, it's 3 dots right in front of you at the bottom of the screen. They're actually, as I look at you, they're right on your shirt.
Okay, well, I don't have that. There's nothing on my shirt. And
No,
no, I know. But the 3 dots I have, they say more underneath, and then it says disable video receiving.
I wonder if I hit spotlight video, what would that do? Or pin video? Would that do anything?
Spotlight.
Spotlight?
Spotlight, the interpreters.
Okay.
Oh, that's
All
Mary.
right, wait, hold on. Spotlight 2. Oh, wait, I can only do one at a time.
Okay.
What if I pin it?
That only works for you.
Oh.
Mary, I know sometimes we found with video, if you're using the browser versus the app, whatever one you're using, if you try
I
the other
always
one.
use I always use the app, and today for some reason when that opens up, it's saying launch URL launcher, and I'm like, okay, fine, whatever you have to do, do it. And I click, and it goes nowhere for 10 minutes. So, but
Other idea I
Okay.
have is go to the Zoom website to their updates and update.
And I would like, if it's possible for you guys to work this out, I want to make sure that Mr. Mistral has access, but I have to say that Mr. Kareem has been at 3 meetings, as has Ms. Lamfer, on this first case. And I feel very strongly that now that we have an interpreter here, we need to get their case heard.
I'll be back.
Okay. Okay. So I apologize to everyone for that. So yes, Deb, do your thing.
So, welcome back, everybody. Cases will be called in the order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded.
Hold on.
Procedural.
Hey,
I'm
Deb.
so sorry. Yeah,
Deb,
sorry.
Yeah. Could we take a
Yes,
pause
sorry.
so that Mr. Bonds can interpret this for Mr. Kareem?
Yes.
هي عم تحكي على ترتيب الإجراءات اللي هلا في هذه الجلسة، وإنه كيف حيتنادى على قضية وراء قضية، وإنه الوقت المتاح هلا مبدئيا هو 10 دقائق. Yes, ma'am.
Okay.
Okay.
Go ahead, Deb.
Procedural rules of the commission specify that your arguments may address only. Do you want me to? I'll pause.
Yep.
نحن اجراءات الجلسه حتكون انه تضمن لك انه انت يعني تتحدث والناس تتحدث عن قضيتك بالضبط.
One, relevant factual errors. 2, relevant omissions from the report of facts submitted during the
Just a moment.
investigation.
Just a moment, ma'am. Yes. So again, number 1, please, ma'am. Number 1, you said.
Number 1, relevant factual errors.
أيوة. فإذا كل شيء ما يتعلق تمام متعلق في القضية. Yes, ma'am. And number 2.
Number 2, relevant omissions from the report of facts submitted during the investigation.
هلا أيضا إذا في هناك أي أشياء يعني لها علاقة ضرورية وقد تم حذفها من التقرير. Yes, ma'am.
Or 3, relevant issues and questions concerning interpretation of the law.
وأيضا في المسألة الثالثة هي القضايا المتعلقة فيما يتعلق بشرح نصوص القوانين.
The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party.
يعني طبعا الأطراف لها الحق في أن تعترض على ما جاء في التقرير الشخص الذي قام بالتحقيق. نعم.
Please be advised that commissioners may ask questions and you'll be asked to introduce yourself when it's your turn. Thank you.
طبعا كنت تعرفوا انه اعضاء اللجنه يمكن ان يسالوكم اسئله ويجب انكم انتم تكونوا جاهزين للجواب عليها. عم تسمعني؟ Do you hear me?
نعم اسمعك واضح واشوفك يعني.
Yes, so he said it's clear my voice and he's seeing me well.
Great. Deb, did you finish the intro remarks?
Yes, I did.
Okay.
هاي المقدمة كانت.
Deb, do you want to call the first case?
So the first case, E19-0014, Ahmed Kareem versus Uber. Is there anybody here for Mr. Kareem?
So هلا أول قضية هي قضية السيد كريم ضد أوبر. قالت رقم القضية، بعدين سألت إنه هل في هناك حدا هون بده يحكي باسم السيد.
And
Yes, ma'am.
hold on, before you start, usually we give 10 minutes for each side to say what they want to say, but to allow for interpreting to happen, I'm going to, and because the language interpreting doesn't happen at the same time the way that ASL does, I'm going to allow 15 minutes here to make sure that Mr. Kareem doesn't miss out on any time.
إذا هلا هون السيدة قالت إنه بما إنه نحن عنا الوضع خاص في هناك ترجمة متلاحقة، وبالتالي عوضاً عن ال10 دقائق اللي كانت أصلاً مفروضة إنه هي الحق لكل طرف إنه يحكي، عطت له 15 دقيقة. يا ريت وقت تسمعني تقول لي نعم أو
نعم.
تقول لي نعم. Yes.
Okay, Mr. Kareem.
Yes.
Go ahead.
تفضل يا سيد كريم.
أشكرك أنا عن المطاولة، بس أنا اشتكيت على شركة أوبر لعدة أسباب.
So, I filed a claim against Uber for many reasons.
عملت في شركة أوبر بال 2017 كان عملي جيد وياهم.
I started 2017 and things were good between us.
يعني كان يدخل لي دخل زي جيد وعين عائلتي وكان كل شيء تمام.
My income was good and I could support my family and everything went well.
أنا أول ما جيت لأمريكا 2015.
I arrived at the USA 2015.
الشهر السابع. أنا لما جيت أنا ما أعرف.
In July.
ولا أتكلم ولا بس أفتهم يس أم.
So when I came I couldn't speak. كنت تفهم شوي إنجليزي؟
أفتهم لا أنا أول ما جيت
yes.
بس
yeah.
أعرف يس أم نو بس.
So when I came to United States I couldn't speak English. All what I understood was yes and no. تفضل.
ساعدني صديقي هنا، هو مقيم هنا صار له 13 سنة، ساعدني في تقديم على شركة الأوبر، يعني سجلت بشركة.
So there was a friend who lived in America for 13 years. He helped me in applying to the Uber company.
شرح لي على الأوبر شلون أوصل العالم بالعربي، يعني هو من لغتي ومن بلدي.
And he explained to me in general, of course in Arabic, in our native language.
وعلمني خطوة خطوة.
Sorry. How the works goes and how to get people to where they want to be God. Yes.
علمني خطوة خطوة. أنا ما كان عندي إيميل، يعني ما كان عندي إيميل، هو سوى لي إيميل وعلمني خطوة خطوة
So he explained for me step by step about that, and I didn't have an email. He created for me an email. تفضل.
وأنا كنت بالتكنولوجيا مو هالقد، يعني أنا هو علمني إنه أستخدم الإيميل، هو يعني أنا التكنولوجيا مو قوي بيها، يعني ما أعرف إنه.
So as a matter of fact, I am not strong in technology, but he taught me how to use my email.
كانت بالشركة مال أوبر ما يصير واحد يسجل إذا ما عنده إيميل أدرس أو هاي. المهم أنا.
So for Uber, it was not acceptable for anybody to be employed unless people get their emails.
أوكي، اشتغلت في 2017 بشهر الرابع تقريبا.
I began working in April 2017. 17.
وكانت تجيني ايميلات يعني كنت دا اشتغل زين بعده يعني اماكن رحت يعني بدايه مدار مين بورتلاند
Uh-huh.
يعني
So the work was good, and I drove people to many places in Portland and other than Portland.
كانوا يساعدوني وياي زبائن يحجون انا ما افتهم عليهم بس اقول لهم
عفوا ما فهمت عليك.
يساعدوني وياي زبائن كانوا يساعدوني زبائن خاصه بالويكند كنت ما افتهم عليهم يعني يحجون
على الزباين ما تفتهم على الزباين.
اي ما افتهم على الزبائن يجي يحجون.
Yes. So it happened. So لحظة بالله لحظة. It happened that sometimes clients were asking me questions, but I couldn't understand them. تفضل.
خاصة بالويكند يعني خاصة بالايام
particularly in the weekends.
يعني كانوا يساعدون سكرانين كانوا يساعدون يعني كثير من الرجال وكثير من النساء. المهم كانوا يعني
عفوا شو الرجال والنساء ما فهمت.
يعني يساعدون سكرانين.
Yeah. So because some men, some women were in the weekends were drunk.
كانوا يسألون أسئلة يعني من لون بشرتي من لون حكي إنه
they asked me questions about the color of my skin, about my accent.
أنا أقول لهم أنا ما no speak English so I speak Arabic.
So my answer was I don't speak English. I speak Arabic.
كانوا بيهم يتلاطفون وياي ويسخطون وكان بيهم منهم مع بعض يستهزئ بي كان بيهم
وكان في منهم شو يعملوا؟
يعني يتعاطفون وياي يرحبون بي بعض بيهم.
So some of them, as a matter of fact, some of them were sweet, compassionate, and nice. Yes.
وبعض بيهم يستهزئ ينتقص من شخصيتي ومن
And
كرامتي.
some of them were mocking.
وبعض بيهم انه مثلا يقول لي انت ليش جيت لهنا يعني هواي اسئله.
And some of them asked me, so why did you come to here?
أنا كنت ما أعرف أكتب ريبورت يعني ما أعرف أكتب اللي يحكون وياي لأن أنا ما أعرف أستخدم الإيميل. كنت أروح كل فترة صديقي اللي سوى البرنامج علمني عليه كل فترة يعني هو كان طالب كلية كل فترة يساعدني.
So بس أنت ما كنت تعرف تكتب الريبورت؟
ما أعرف أكتب ريبورت يعني ما أعرف إنه أكتب إنه هذول هذا تجاوز يجي عليه وهذا.
Okay. So as a matter of fact, I didn't know how to write down the report, which is about what happened with me, etc. So from time to time, I went to my above mentioned friend to tell him to help me in using my email. تفضل.
اجتني فتره من الفترات اروح لصديقي كل فتره يعني بالاسبوع مره اقول له يابا هذني اجتني ايميلات افتح لي اياها هو كان مشغول او مثلا عنده دراسه فانا تجيني ايميلات انا ما اعرف اقرا شنو. المهم
ما تعرف تقرا؟ نعم.
اقرا الايميل اللي كان يجيني من اوبر.
نعم.
كانت زوجتي تساعدني تجيني عروض مثلا بهذا الويكند اكو عروض انه اكسترا ماني بالويكند او مرات تجيني هاي مرات تجيني ايميلات انه اكو اشخاص يشتغلون علي.
لحظه بالله لحظه. So I have received emails from Uber. It was about some offers. As a matter of fact, I couldn't understand. Sometimes I asked the help of my wife, and sometimes I went to my friend from time to time. نعم. عن شو الإيميلات كمان؟
إيميلات يعني مرات يقولوا لي إنه مثلا عروض تجيني ومرات تجيني إنه مثلا أكو سيرش بفلان باقة. المهم
شو هي؟
بعض الأحيان تجيني عروض من شركة. نعم. بمناطق إنه أكو شغل قوي هنا. بعض الأحيان
من أوبر عفوا من أوبر هاي.
نعم.
So sometimes I in these emails there was a kind of offers about working rewarding works in some areas of the state. تفضل.
انا بس اريد اقول لك بال 2018 بيوم القديس هذا يوم الاخضر.
يوم شو؟
يوم العيد، عيد الاخضر. قديس باتريك، قديس باتريك.
سان باتريك دايز. اوكي يس.
وقفونا عن العمل نهائيا. قبل هاي الفترة.
So in 2018 at St. Patrick's Day they stopped me from working. Yes. تفضل.
قبل هاي الفترة انه انت توقفت عن العمل وجدتك ايميلات انه عالم يشتكين عليك، عالم 6 اشخاص مشتكين عليك بصورة غير اخلاقية، وانه انا متجاوز عليهم ومتعدي عليهم اخلاقيا وجسديا.
اوكي لحظة بس. So and in the email they said that I am stopped from working. They said that you received many emails in which we talked about complaints from people, 9 people, you know, that you as a matter acted, behaved in a not immoral way, and even you physically abused them.
بهذا الايميل جاني يقول لي انت اكو اشخاص خلال 6 شهور مضت مشتكين عليك، نفس يعني عده اشخاص نفس الشكوى.
أنا ايميل هذا
ويصير انه نفس الشكوى.
هلا بسان باتريك وقفوك وبعثوا لك ايميل، بعدين شو صار؟
بهاي دزولوا بهذا الايميل بهذا اليوم القديس انه خلال هاي 6 شهور مضت انت مشتكين عليك 6 اشخاص.
نعم.
6 اشخاص نفس الشكوى، وهو
التحرش
الجنسي.
شو هي؟
التحرش الجنسي، يعني انا بتحرش فيه.
خلاص. So in the email they've sent me in the St. Patrick days stopping me from work, they said that these 9 people, they have the same complaint against you. It is sexual harassment.
أنا انصدمت بهذا القرار يعني بإيميلهم. أنا رجعت نفسي. أنا ما أول شيء ما أعرف أحكي، ثاني شيء ما
أول شيء شو؟
ما
أول
أعرف
شيء
شلون أتحرك. ثاني شيء أنا ما عندي جرأة، ثالث شيء أنا متزوج، هاي زوجتي معاي.
So خلاص فهمت عليك. لحظة. So I was completely surprised by this info because first of all I cannot speak English. First of all, second, even I don't have the courage to do such a thing. Third, I am a married man. تفضل.
رجعت اتصلت بأوبر ما ردوا لي، دزيت لهم ايميل قالوا احنا نشكرك على الفتره اللي قضيت وياها بينا وانت خارج عنا وانت بعد نهائيا ما ترجع. انا
So لحظه. So I replied to Uber and what they've said, thank you for your reply, and thank you for your service, but you are now out of work.
يعني حتى لما طلعوني ما اعطوني الحق ارد على نفسي، ما اعطوني الحق، ولا واحد خابرني قالوا يابا انت ما تحكي انجليزي تعال عندي اكو مترجم هيك وهيك وهيك. ما حط
Okay. So when they let me off, they didn't give me the chance to explain. Nobody called me, phoned me, giving me the chance to say my point of view. تفضل.
ولا اعطوني ايميل تثبت انه اني هاي الشغلات مسويها، يعني ما دزوا لي.
And they didn't send me any email that proves that I did what they said I did.
رجعت اني على زوجتي، قعدت وياها حكيت وياها، قلت لها لازم اني ارجع يعني اخذ حقي، انه انا ابرر نفسي انه انا ما مسوي هذا الشيء.
So I asked for the help of my wife that I need to have my rights back and my work back.
رحت المكتب صغير كل يوم ثلاثاء واربعاء يفتح بساوث بورتلاند، مكتب صغير بالاسبوع يوم او يومين يفتح. رحت لهم العفو، سويت موعد وياهم ورحت لهم، شرحت الوضعيه. قال انا حاستفسر من المدير وارد له خبر، يعني اخذ معلومات وما رد لي خبر.
So it seems that they have some opportunity for people on Tuesday and on Wednesday in some place in South Portland to come and to explain. And I did that, and the one who listened to me said, yes, I got it, and I will let my supervisor know, and then we will come back to you. But till now, nobody contacted me.
So we're almost out of time. You have about 20 seconds left, Mr. Kareem.
يعني باقي لك يا سيد 20 ثانية. إذا عندك شيء أخير تقوله بهال 20 ثانية تفضل.
رحت المكتب ببوسطن، اخذت زوجتي واخذت طفلي، رحت لهم وشرحت لهم، قلت لهم انا ليش طلعتوني. المكتب كان تعامل حيل مو زين وياي، وحتى باسلوب ما حلو. قال لي انت بعد نهايه انت تشتغل ويانا، وقال لي انت متعدي حتى على اشخاص، يعني ولد. قلت له انا متعدي على ولد؟ مستحيل. قال لي متعدي على
ولد وعلى اولاد، يعني اطفال؟
لا مو
أوكي.
لا مو على اطفال، على اشخاص سكرانين ولد.
أيوة.
يعني بكبرنا.
رجال؟ شو هاي؟ شو ولد يعني؟
ولد اشخاص.
ولد.
ايه
اشخاص. خلاص.
اشخاص يعني
I've been خلاص I've been to their office, and as a matter of fact they treated me not in a nice with my wife, and as a matter of fact they treated me not nicely. I tried to explain. They said you are not working for us anymore, and as a matter of fact you were aggressive to some people.
انا بس اريد اقول اخر كلمه. بابا انا عربي وانا مسلم وانا رفيجي وما اعرف احكي انجليزي، شلون سويت هاي الشغلات كلهن بهذا الوقت؟ وانا ما اعرف حتى هسه انا يعني كل الكلام اللي يحكوه ما دا افتهم كله، يعني تقريبا دا افتهم 25%. ليش اطلب من ترجمه؟
So my last thing to say that I am Muslim, I am Arab, and I don't speak English. How could I say these things that they claim that I have said? And as a matter of fact, when they talked about that, only 20% of 25% of what they said I could understand. So how could I say that?
حتى اكو اشخاص تجاوزوا علي، اكو اشخاص سيدات تجاوزوا علي وضربوا الباب حيل، ويعني ضغطوا علي، بس انا ما اعرف اكتب.
ضربوك؟
لا ضربوا الباب.
So even there were people, you know, I mean, the passenger, there were people that behaved not in a nicely way, slapped the doors, were aggressive.
وانا قدمت الشكوى.
Mr. Kareem, I'm trying to be fair, and I know you've waited a long time to have access to this hearing, but I think you've gone over the time that I have given you, even allowing for the interpreter.
إذا سيد كريم هي بدها تحاول إنه تكون منصفة، ولكن يعني أعطتك وقت أكثر، يعني في أشخاص آخرين وأعطتك وقت أكثر من
شكرا لأن سمعتوني، وأنا قدمت شكوى على شركة أوبر وأريد حقي وينصفوني من شركة أوبر.
So thank you for listening to me, and what I want is to have my rights. That I will be treated in a fair way from Uber company.
وآخذ كلمة، حتى يعني شركة أوبر قدمت العروض أسحب الشكوى، وأنا ما قبلت أسحبها إلا آخذ حقي من شركة أوبر ويثبتون براتي إنه أنا هذا ما مسوي كله.
Mr. Kareem, I'm sorry, but I have to say that your turn to speak is finished, and now we're going to hear from Uber.
Okay. Sorry.
Mr. Bonds, do you need to interpret that?
So اسفين نحن خلص وقتك وحتسمع من اوبر. يسمع.
So just so I can ask Mr. Kareem, I am assuming that you will want Mr. Bonds to interpret for Ms. Landfer also, but is that right or wrong? I don't know.
هلا هي عم تقول انه حضرتك بتريد انه انا المترجم اني كمان ترجم للمندوب الاوبر. هل صح بدك يعني ترجم ولا لا؟
هي ترجم عادي.
Yes, of course. Yes, I do.
Okay. Before we move on, I need to check with the commissioners to see if they have questions for you, Mr. Kareem. So let me ask the commissioners first. Commissioner Whitman. Oh, I'm sorry.
No problem. أول شيء بدي تسأل أعضاء اللجنة إنه هل هن عندهم أي سؤال لك. هلا بدك تتوجه لأعضاء اللجنة. يسمع.
Commissioner Whitworth, do you have any questions for Mr. Kareem?
No questions, thank you.
Go ahead, sorry.
ما في سؤال. يسمع.
Commissioner Hellberg, any questions for Mr. Kareem?
Yes. I'm wondering if he completely understood the complaints that were against him and his response to those complaints seemed to be negative, but did he completely understand the complaints against him?
هلا هو بده يتأكد انك انت هل فهمت تماما التهم الموجهة او الشكاوى الموجهة اليك. طبعا هو فهم، هذا عضو اللجنة عم يحكي، هو فهم انك انت يعني اجبت بالنفي، بس هو بده يتأكد انك انت فهمان شو هي الشكاوى.
انا افتهمت بعد الرفض، ما افتهمت بعد الإمانة، افتهمت بعد ما رفضوني،
بعد ما اطلعوك من العمل. Yes, I understood. Okay, I understood the complaint, but after they laid me off, not before.
No other questions.
Commissioner David, any questions for Mr. Kareem?
Excuse me, yes. You indicated that there were 9 complaints, correct?
فإذا أنت ذكرت إنه في هناك 9 شكاوي، صحيح؟
أنا 9 أو ما أتذكر بوقتها، بس هي 9 أو 6 أو 7 ما أتذكر بوقتها.
I am not sure exactly. Is it 9? Is it 6? Is it 7?
ما أتذكر هيك شيء. إنه هم دزوا لي رسالة إنه هيك رقم صحيح.
Was it after all of those complaints, whether it was 6, 7, or 9, that you went to the office in South Portland and had the meeting with the Uber people?
هلا بعد ما حصلت هذه الشكاوى، بعد كل هالشكاوى انت رحت على مكتبهم في ساوث بورتلاند واجتمعت معهم؟
انا بعد ما رفضوني يلا رحت لمكتبهم. انا هذني الشكاوى
I have been there after that when they laid me off.
بعدين لما رحت لبوسطن يلا عرفت هذني 9 شكاوى علي. انا ما اعرف
لما رحت لوين؟
بوسطن. البوسطن، وانا رحت لساوث بورتلاند ورحت لبوسطن.
شو اسم المدينة؟ بوسطن؟ بوسطن.
ايه
اوكي. So
ما قالوا لي 9 شكاوى عليك، ما قالوا لي.
So I've been to 2 places as a matter of fact. One in South Portland and the second in Boston and ما قالوا لك شو هي الشكاوى 9؟
South Portland ما قالوا لي عليك 9 شكاوى.
So in South Portland they didn't really explain to me about the 9 complaints.
في بوسطن المقرهم الرئيسي يلا قالوا لي عليك 9 شكاوى وبعد لا تجي.
But in Boston, in the main headquarters, I was told that there is 9 complaints against you.
بعد لا تجينا وما دحاتنا تشتغل يعني.
نعم.
قالوا لي بعد لا تجي هنا طردوني ومدى الحياه مدى الحياه بتشتغل يعني.
So, and I was told not to come over again, and you are forbidden to work to work for us for all your life.
My question is, why didn't you respond and go to those offices and talk to somebody as the complaints came in? I believe you're saying that you waited until you had already been discharged.
يعني هو ليش عم يقول ليش أنت ما من قبل ما تسرح من العمل ما رحت على هالمكاتب وشرحت لهم؟
ما دزوا لي اي شيء، ما دزوا لي اي شيء فات انه انا علي 9 شكاوى، ما دزوا لي ايميل.
So they didn't send me anything that indicates that there are these kinds of complaints against me.
حتى لو دازيلي انا اول شيء ما اعرف اقرا الايميل، لازم اتصل على المفروض يخابروني ويا مترجم يلا اعرف.
Even in case that they send me something, I cannot read it. I cannot read it. What they were supposed to do is to contact me over the phone and in the presence of interpreter and to tell me what they want to tell.
My other question, in your submission to the commission here, you say that there are other drivers that are experiencing the same kind of discrimination from Uber. Do you know of any specifically in this area?
I'm going to stop you there, Ed, and say that if it's not information that's already been submitted to the investigator, it can't be considered.
Okay, well, that was my question, whether he submitted it to the investigator. So I guess not.
So I mean يعني اللي حكى هلا انه sorry sir just one moment اللي حكى انه عم بيقول هو انه انت باعتراضك قلت انه في اشخاص اخرين تعرضوا لنوع من التمييز يعني السلبي فهي جاوبته انه هالمعلومات لم تقدم الى المحقق.
ما عندي وقت، انت معطيني 15 minutes، انا عندي ورقه 1 hour ما اخلصها.
So I have a lot to say. You see, he showed us a paper. He said, I have a lot to say. Maybe it will take me 1 hour to say it.
No, it's beyond the scope of this investigation, apparently.
هلا معناها هذا الموضوع خارج موضوع هلا التحقيق تبعنا.
اوكي ما عندي وقت.
I think, Commissioner David, I just wanted to tell you that the investigator, I think, can answer some questions.
Right, I'm going to ask her that too. Mr. Karim, do you use any social media accounts such as Facebook, Messenger, Twitter?
عندك يا سيد كريم أي حسابات بالميديا يعني أنت موجود على الفيسبوك، موجود على تويتر، موجود على الماسنجر؟
And before you answer, Mr. Karim, nope, don't answer yet. Because it's not in the record.
There's a specific allegation, Amy, that he made a contact on social media.
I know he has said that now, but I don't.
No, the investigator says that.
Oh, Jane, I think the investigator just messaged me to say that the issue of what social media he has is not in the record, but perhaps that is something that.
Well, all right, I'll ask it as a direct question. Have you ever communicated with a passenger on any social media?
طيب السؤال هلا المباشر لانه صار في نقاش انه هل هذه المعلومات معروفه لدى المحقق ام لا؟ هلا السؤال المباشر، هل اتصلت مع اي شخص من المسافرين عبر السوشيال ميديا، يعني عبر الفيسبوك او عبر التويتر او عبر؟
انا كل الحسابات عربيه، شلون اتصل بيهم؟
انت بتحكي عربي بس؟
كل الحسابات عندي فيسبوك بس عربي، شلون يتصل؟
So no, and all the accounts I have in social media are in Arabic.
شلون اتصل بيهم وانا ما متصل باي واحد.
I of course I didn't contact anyone.
Thank you.
Thank you. Okay, so at this point, we're going to move to Ms. Lanfer and hear from Uber. And again, I'm going to give Ms. Lanfer, I'm going to make this 15 minutes as well to allow for the interpreting.
هلا حتعطي مندوبة الأوبر الوقت، وأيضا حتعطيها 15 دقيقة مو 10 لأنه في هناك وقت للترجمة. مام.
Thank you. And please stop me, interpreter or Ms. Nearson, if I'm going too quickly. My name is Francesca Lanfer.
So just طلبت إنه يعني إنه تتوقف إذا مثلا حكت بسرعة أو طولت، إنه مشان إنه بتصعب على الترجمة إنه نوقفها. Yes, ma'am.
My name is Francesca Lanfer. I'm appearing on behalf of Uber.
هي فرانشيسكا هي هلا اليوم عم تمثل الأوبر.
Mr. Karim raises 2 points in his argument today that I would like to respond to.
فإذا السيد كريم قد طرح مسألتين اليوم أنا بدي جاوب عليهم. مام.
He first claims that he did not receive notice of the complaints against him from the riders.
أول شيء هو ادعى أنه لم يستلم إخبار عن الشكاوي اللي كانت ضده.
And he second claims that his English language barrier would prevent him from participating in any of the alleged complaints against him by the riders.
والنقطة الثانية اللي أثارها السيد كريم إنه هو قال إنه اللغة أو حاجز اللغة كان يمكن سيمنعه من إنه يرتكب الأشياء التي تقول الشكاوي أنه ارتكبها.
The record shows that one, Uber indeed sent notices to Mr. Karim each time a complaint was received, shortly after the complaint was made.
هلا الوثائق بتقول إنه الأوبر أخبرت السيد كريم بكل شكوى بعد حدوث هذه الشكوى. نعم.
These notifications were sent to complainant by email.
هلا فإذا هذه الإخبارات أو الإعلامات عن الشكاوي تمت بواسطة الإيميل. نعم.
And the record shows that this email account to which the notifications were sent.
The email account, sorry, ma'am.
Sorry, I'll finish my my sentence. The record shows that the email account, Mr. Karim's email account to which the notifications were sent is the same email account that he used during this investigation to communicate with the investigator. And also, Mr. Karim stated today that he did in fact receive emails from Uber of a different nature. He said he received some sort of offer, and all of the emails that Uber used to communicate with him was the same email account.
So هلا هي عم تقول إنه الإيميلات التي أرسلتها أوبر إليك هي كانت على الإيميل نفسه يلي استخدم للحديث والتخاطب مع جماعة المحققين، وإنك أنت أيضا قد قلت إنه فعلا إنك أنت استلمت على هذه الإيميلات هالأنواع من العروض.
And so each time the notification was sent, Uber cited to the community guidelines that Mr. Karim agreed to when he signed up with Uber.
فإذا كل شكوى من هذه الشكاوى كل شكوى مش أخبر عنها بإيميل حسب الأصول أو الشروط المتبعة بأوبر واللي أنت موافق عليها.
And emphasize that multiple complaints of the same nature could result in deactivation of his account.
So in the I didn't get that. What do you mean by that exactly?
If there are, so Uber notified Mr. Kareem in these emails that the same type of complaint could result in deactivation of his account, of his Uber account.
The deactivation.
Yes.
I understand. And كمان بهالإيميلات خبرتك الأوبر إنه هذه الأفعال ستؤدي إلى إبطال إمكانية التواصل مع إيميلك.
Mr. Kareem was given plenty of time to respond to these complaints.
السيد كريم قد أعطي وقتا كافيا لكي يجيب على هذه الشكاوي.
The first complaint took place in July of 2017.
هلا أول شكوى حصلت في الشهر 7 من 2017.
And took place, and the 6 complaints that Uber has on record took place over the course of months thereafter, with his deactivation taking place in March of 2018.
The last one in March 2018?
Yes.
So بعد هذا الوقت في 6 شكاوي تم الإخبار عنها من أوبر بالفترة من شهر 7 وآخر واحد كان شهر 7 2017. آخر واحد كان شهر 3 2018.
And based on these complaints, Uber chose to end its contractual relationship with Mr. Kareem.
وبناء على الشكاوي قررت الأوبر إنه تقطع علاقتها العملية مع السيد كريم.
The second point that Mr. Kareem raises is that his language barrier would prevent him from participating in some of these alleged complaints against him.
هلا النقطة الثانية التي أثارها السيد كريم بأن حاجز اللغة عدم معرفته للغة كان يمكن سيمنعه من أنه يقوم بهذه الأشياء.
But at least 3 of the complaints did not actually involve communication or verbal communication of any kind.
ولكن بالحقيقة في 3 من هذه الشكاوي لم يجري ذكر أي شيء عن موضوع تواصل بالكلام.
They were instead complaints about riders feeling uncomfortable with his traffic maneuvers and his driving.
أول شيء كان في شكوى من إنه ضد نوعية طبيعة سواقتك. Yes, ma'am.
Or his body language, for example, staring and making the rider feel uncomfortable.
أيضا الشكوى ضد حركات أنت قمت فيها بجسدك خلت تخوف المسافر وتخليهم ما يشعروا بالاطمئنان. نعم.
And so in the end, there's no evidence that Uber considered Mr. Kareem's national origin or religion in making its determination to end its contractual relationship with him.
Would you say that again, please, ma'am?
Ultimately, there is no evidence that Uber considered Mr. Kareem's national origin or religion in making its determination.
Yes, ma'am. فإذا ليس هناك أي دليل يثبت أن أوبر قد اتخذت قرارها بناء على أنك أنت أصلك القومي منين جاي أو بناء على دينك.
Thank you.
شكرا.
اقدر اجاوب؟ انا ما
May I answer?
انا ما قلت لها هم شركه اوبر اشتكوا عليها، هم الاشخاص.
Nope. Mr. Kareem, you do not have an opportunity to ask any questions at this point. You use
أنت ما عندك يعني بهالنقطة هلا ما عندك أي حق هلا أنك أنت تجاوب عليها.
Do commissioners, I'm going to ask the commissioners if they have any questions for Uber.
فإذا هلا حتسأل الأعضاء اللجنة إذا هن عندهم أي سؤال لممثل أوبر.
Commissioner Whitworth.
No questions, thank you.
لا سؤال.
Commissioner Helberg.
Just one question. Was there ever a face-to-face meeting with Mr. Kareem where the complaints were discussed?
سؤال واحد هون عضو اللجنة، هل هناك كان مقابلة شخصية وجها لوجه مع السيد كريم وضحت فيه هذه الشكاوي؟
Not to my knowledge, Commissioner. As we discussed, the record shows that Uber used email to primarily communicate with Mr. Kareem, as it does with all its drivers. Go ahead.
يعني أنا حسب علمي لا، وإنه هي شركة أوبر تواصلت مع السيد كريم عبر الإيميل كما تفعل مع بقية العاملين. مام.
And like I said, he did not respond or request an in-person meeting prior to the deactivation of his account.
And one other question, was there anything different?
Can you hold on 1 second so that the interpreter can interpret that?
Yes. So وهي حسب علمها إنه أنت ما جاوبت، يعني ما جاوبت على أي شكوى من الشكاوي اللي قالوا لك إياها قبل ما يقطعوا لك حسابك تماما.
أنا ما أعرف أجاوب.
Nope. Mr. Kareem, we are not hearing from you at this point. Commissioner Helberg.
يعني ما لك هلا الحق إنك تتدخل. مام.
Commissioner Helberg, did you have another question?
One last question to Uber. Was there anything different or unusual in the interaction with Uber to Mr. Kareem regarding these complaints?
هلا سؤال أخير لأوبر، هل كان هناك مختلف بتصرف أوبر وقت تصرفت هي بالذات مع السيد كريم؟
Not to my knowledge, if I'm understanding your question correctly.
لا، أنا إذا فهمت سؤالك لا، ما كان في أي اختلاف عن الآخرين بالتصرف مع السيد كريم.
That's all I have.
Sorry, Commissioner David.
No questions.
Okay,
ما
thank
في
you.
سؤال.
Thank you. So we've heard from the complainant and from the respondent, and at this point we would hear from the investigator, Jane O'Reilly.
هلا نحن سمعنا من الطرفين وهلا بدنا نسمع من الشخص اللي قام بالتحقيق.
And Jane is a fast talker, so Jane, don't forget to leave time for the interpreting.
Thank you, Amy.
المحققة هي بتحكي بسرعة، فقالت لها ما تنتبهي ما تحكي بسرعة حتى تتركي فرصة للمترجم إنه يترجم. مام.
Good morning, commissioners. My name is Jane O'Reilly, and I was the investigator on this case.
هي اسمها جين أوريلي and هي كانت المحققة في هذه القضية. مام.
I have no additional information to add to the parties' arguments.
أنا ما عندي أي معلومات إضافية للشيء اللي قالوه الأطراف.
I'm just going to add some clarifying information based on Commissioner David's questions and a few other factual issues.
أنا بس حضيف بعض الأشياء يلي إلها علاقة سؤال السيد ديفيد عضو اللجنة وبعض الأشياء الأخرى. نعم.
Mr. Kareem did submit the names of other drivers he's aware of in his area who had received similar complaints.
هلا نعم قد ذكر السيد كريم بعض الأسماء يلي بنفس المنطقة العرب يلي عانوا من نفس الأشياء. نعم.
His specific allegation was that these drivers, like him, had no knowledge of why they were being deactivated.
هلا هو كمان قال إنه هدول الآخرين أيضا هن ما عندهم أي علم لماذا قد توقفت حساباتهم.
I found that was very different from Mr. Kareem's situation, in which he had received several notices of his complaints prior to his deactivation.
وهي وجدت إنه هذا الشيء مختلف تماما عن وضعك لأنك أنت قد استلمت عدة إخبارات عن الشكاوى.
There were also some factual statements that Mr. Kareem made in his presentation today that are not in the record.
هلا في هناك بعض الأشياء يلي حضرتك قلت اليوم بفمك ما لا موجودة كانت على الملف. نعم.
However, they are very consistent with his submissions and do not change my recommendation, and I'll go through what they are, what those.
بس هذه الأشياء الذي قالها السيد كريم واللي لم تكن مذكورة بالملف هي متناسبة ومنسجمة مع الأشياء اللي هي موجودة في شكواه ولن تؤثر أنا على اقتراحي وقراري.
Both of the issues relate to his difficulty with English. He went into more specifics about his conversations with passengers.
Would you say it again, ma'am?
Yes, he went into more specifics about his conversations with passengers and the difficulty he has with English.
يعني هو اليوم قد أصرح بأشياء أكثر تفصيلية عن موضوع التواصل الكلامي مع المسافرين والأشياء اللي صارت. Yes, ma'am.
Again, he also went into more detail with his assistance with his email, more specifics about who helped him.
كمان أنت اليوم ذكرت معلومات إضافية عن إنه بالإيميل كيف مين عم يساعدك بالإيميل.
But generally, his lack of ability to communicate well in English was central to his argument, so I did not feel those specifics changed my recommendation in any way.
Would you say it again, the first part?
Yeah. Yes, those the facts he added are consistent with his argument that he has difficulty with English, and so of those facts does not change my recommendation in this case.
Yes, ma'am. So هالأشياء يلي أضفتها مرة أخرى هي متناسبة مع الأشياء يلي أنت ذكرتها في شكواك واللي بالنهاية ما حتأثر على أنا اقتراحي وقراري.
And I have nothing else to add, and I'm happy to answer questions.
أنا ما عندي شيء آخر أضيفه وأنا سعيدة إني أتلقى الأسئلة.
Thank you, Jane. Commissioner Whitworth, any questions for the investigator?
No questions.
سألتها عضوة اللجنة قالت عضوة اللجنة ما عندي سؤال.
Commissioner Hellberg, any questions for the investigator?
I have one either for the investigator or for Uber, but does Uber have, to your knowledge, or if it's in the record, a specific progressive discipline policy that it followed or not?
I'm going to see if the investigator has an answer to that first,
Right.
and also if it's in the record.
Right.
So هلا هو عم يسأل إنه هل في هناك عند أوبر أصول أو يعني إرشادات كيف بتتصرف بالسياسة اللي بتتعلق كيف بيتصرفوا بهيك أشياء؟ هلا أسأل أول شيء المحقق. Yes, sir. Yes, ma'am.
What is in the record is that Uber has community guidelines for its drivers.
هلا مكتوب بالملف إنه الأوبر عندها موجود كتابة إرشادات تتعلق بموضوع السواقة
And that, sorry. And that with each complaint, he received warning that continued complaints could result in deactivation.
وإنه في كل إخبار له عن كل شكوى هو قد حذر من إنه هذه الشكاوي قد تؤدي إلى إيقافه عن العمل.
I'm not aware right now of any progressive discipline policy.
هي ما يعني ما لم عارفة تمام على إنه شو هي طبيعة الإجراء، عنده إنه أوبر عنده سياسة على طبيعة الإجراءات اللي تتخذ في هذه الأحوال.
Okay. Another one quick follow-up. Just to be clear then, so he received these emails which said it could result in deactivation and was aware of those. Is that correct?
فإذا هو حتى نتأكد أكثر هو وصلوا أرسل إليه هذه الشكاوي مع التحذيرات وهو كان يعرف بذلك.
It is correct that he received the complaints by email and that I found that that meant he had knowledge of them. Mr. Kareem contends he did not have knowledge of them until he was deactivated.
So نعم هو قد استلم هذه الإيميلات وهو قد عرف بها هلا، ولكن السيد كريم يقول أنه هو لم يكن واعيا بها.
As Attorney Lanford pointed out in her presentation, the same email was used for all of the complaints and the notice that he was deactivated, to which Mr. Kareem did respond.
هلا نفس الإيميل الذي استخدم لا إخبار السيد كريم بهذه الشكاوي هو نفس الإيميل اللي تم إخباره فيه بأنه توقف عن العمل، وهذا الإيميل بالذات هو قد أجاب عليه.
بس أنا ما كنت أفهم.
Any, Commissioner Hellberg, any other questions for the investigator?
No, thank you.
Commissioner David, any questions for the investigator?
Yes, Jane, I'm still troubled by the issue of contacting other people in the same class.
عم يسأل المحققة إنه هو لا زال يعني غير مرتاح لقصة إنه كيف بيتم التواصل مع الناس اللي لهم نفس الموضوع. Yes.
You say that he provided multiple names of other employees who were members of the same protective class and discharged without being given a reason. I understand you're distinguishing the fact that he was given a reason.
هلا أنا يعني would you say that again, sir, please?
You say that he provided multiple names of other employees who were members of the same protected class and discharged without being given a reason.
Sorry, sir. What do you mean by protected class exactly?
I'm quoting from the investigator's report.
Do you mean because he speaks Arabic or is from another country, Ed?
Well, I mean, that's a question for her, but no, I think it's religion or national origin is the beginning of the paragraph.
هلا هو عم يقول إنه أنت صار في ذكر لا حالات أخرى، أشخاص آخرين هن واقعين تحت نفس المجموعة من مسماها البروتكتد كلاس، سماها الناس المحميين، وأنا كمترجم سألته شو بتقصدوا بهي الكلمة الناس المحميين، والسيدة المديرة للاجتماع قالت هل هذا يعني الأشخاص هن اللي من قومية أخرى أو شيء؟ Yes.
Doesn't that begin, Jane, to make out a case that there's discrimination against that protected class if there's multiple other people?
يعني عم تقول لها مو انه هذا عم يقول لها عفوا سوري، مو هذا يستدعي انه يصير في تحقيقات مع هدول الاشخاص الاخرين يلي بينتموا لنفس المجموعة.
I mean, I can address the factual information that I had in the record, again, based on the fact that those two scenarios were different. I did not find that I mean, it's certainly further investigation to determine that those people had exactly consistent. I mean, I can't hypothesize. I can't say what might have happened if I had looked further.
So هي عم تقول انه هي تصرفت بناء على المعلومات التي عندها، وانه اصلا يعني الحالتين مختلفتين، وهي ما بتعرف اشياء عن الحالة الثانية.
What I have in the record is a list of names and Mr. Kareem's assertion that they were all terminated because of their because of their national origin and religion, because they didn't know why they were terminated.
هلا هي اللي بتعرف انه انت الناس اللي انت اشرت لهم هن ايضا يعني يشتركون بقصة الاصل القومي تبعهم، وايضا يشتركون بانه هن يعني قالوا انه هن ما بيعرفوا بالاسباب التي ادت لهالشيء.
How many did you contact, Jane?
I didn't contact any.
فإذا سأله هو هل أنت اتصلتي مع أحد هؤلاء الأشخاص؟ أجابته أنا لم أتصل مع أحد.
That's all. Thank you. Go ahead, Jen.
I was going to say, I also have a list of people recently deactivated by Uber.
أنا عندي أيضا جدول بالأشخاص يلي توقفوا عن العمل من قبل أوبر. Yes, ma'am.
And none of the names that complainant Mr. Kareem provided are on it.
وأيضا ما في ولا اسم من الأسماء التي ذكرها السيد كريم موجود في لائحة الموقوفين عن العمل.
Nope. No, we're not hearing any information from you at this point, Mr. Kareem.
نحن ما بنقدر ناخذ عن يعني أي شيء منك.
Nothing further, thank you.
Thank you.
لا شيء غير ذلك.
So we've heard from the complainant and the respondent and the investigator. So at this point, it would be up to the commissioners to make a motion or motions.
هلا فإذا سمعنا من المدافع، سمعنا من الشاكي، سمعنا من شركة أوبر، وسمعنا من المحققة. هلا الأمر صار بين يدي اللجنة لحتى تأخذ قرار أو قرارات.
Okay, I'll make a motion.
أنا
to uphold the recommendation of the investigator.
أنا حقول إني أتبع التوصيات التي قالها المحققة.
That there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of religion and or national origin.
أنه ليس هناك أي أرضية حقيقية أو دليل يشير على أن الشركة قد اتخذت من الأصل القومي أو من دين المشتكي سببا كي توقفه عن العمل.
And that the complaint should be dismissed in accordance with the act.
أيضا وأن الشكوى يجب أن تسقط.
So there's been a motion. Is there a second?
Second.
Commissioner Whitworth seconded the motion.
فإذا عضوة اللجنة أيضا قالت إنه هي موضوع إنه الشكوى تسقط.
So is there any discussion among commissioners of the motion?
هل هناك في أي مناقشات بين الأعضاء اللجنة حول هذا القرار؟
None for me.
لإلي ما في. وهي السيدة أجابت لا.
So I heard Commissioner Helberg. Commissioner Whitworth, did you say nothing from you?
Nothing from me.
Commissioner David?
إذا رد أكدت إنه هي ما في عندها شيء تضيفه.
Yes, I'm going to vote in favor of the motion. I think there's ample evidence in this case over 8 months or so of complaints. And I guess it's not relevant that I'm troubled about whether there's something else out there of a more general nature in the area about Uber's treatment of other people in the same class. But in this case, there's no reasonable grounds.
طبعا عم يقول إنه في هذه القضية ليس في هناك أي شيء يدل على إنه في موضوع تمييز. تمام. هو قال إنه أنا أشرت لأشياء أخرى حوادث أخرى ولكن في هذه القضية بالذات ليس هناك ما يشير إلى إنه حصل تمييز. Sir, ma'am.
And Commissioner David, I would just say that it does happen from time to time that a case brings up the possibility that there is some issue that affects similar employees, but the ultimate question we have to answer in every case is whether this complainant was discriminated against. So it is sometimes the commission approaches a side issue, but I appreciate your clarifying your position on this case.
عم تكمل شرح هي سوري عم تكمل الشرح عم تقول نعم إنه هناك بكل قضية بصير في ذكر لأشياء أخرى تحدث قد تكون مشابهة ولكن نحن في هذه القضية بالذات الأمور كانت مختلفة وإنه هي كمان بتقدر يعني إنه عضو اللجنة كان أشار لها المسألة. نعم.
So any other discussion from commissioners before it is called for a vote?
No.
أي شيء بيريدوا يناقشوه أعضاء اللجنة قبل أن ندعو إلى التصويت؟ لا.
So all those, the motion is to find no reasonable grounds to believe that unlawful discrimination occurred in this case. All those in favor of that among commissioners, please raise your hand and say aye.
إذن كل الذي بيقول عفوا يلي بيوافق على إنه ليس هناك أرضية حقيقية للادعاء بأنه قد تم التمييز ضد السيد كريم في هذه القضية خليه يرفع إيده ويقول رفع الثلاثة رفعوا إيدهم.
So all 3 commissioners voted to agree that there are no reasonable grounds to believe unlawful discrimination occurred.
فإذا 3 أعضاء اللجنة صوتوا بالموافقة أنه لا توجد هناك أي أرضية للاعتقاد بأنه هناك كان في تمييز. نعم.
So now the hearing on this case is over. The commission will send both parties a letter describing today's vote and the end of our case. We'll send one to both Mr. Kareem and to Uber. So now we're going to move to our next case. Mr. Kareem, sorry.
Please, ma'am. So هلا فإذا الجلسة بالنسبة لها قد انتهت ونحن بنبلغ الطرفين أوبر والسيد كريم بنتائج هذه الجلسة يعني نرسل لهم رسالة حول نتائج هذه الجلسة. مام.
And I just want to thank Mr. Kareem and Ms. Lamfer for making themselves available for 3 different meetings while we tried to get this hearing to happen.
وهي بتشكر السيد كريم وبتشكر السيدة الممثلة أوبر لأنه حضروا 3 مرات لحتى تم نجاح هذا الاجتماع. مام.
So, Mr. Kareem and Ms. Lamfer, you're welcome to stay. I would, if you do want to stay, Mr. Kareem, I would ask that we try to figure out a way to connect you and Mr. Bond so he can interpret for you. I don't know if there's a way to do it that is
Offline.
yeah, less disruptive to the larger process. That may not be possible, but just let me know if you do want to stay and listen. Otherwise, we're going to move on because we have ASL interpreters for the next case.
May I just ask for, before he interprets, for a 5-minute break as he interprets?
Yes.
Yes,
Thank you.
may I ask something, ma'am?
Yes.
Is it that you are asking Mr. Kareem if he wants to stay and listen to other cases?
Yes.
هلا هي عم تسأل سيد كريم، أنت معي سيد كريم؟
نعم معك.
هلا هي عم تسألك أنت إذا بتحب إنك تضل قاعد موجود بالاجتماع، في هناك يعني هلا بقى قضايا أخرى غير قضيتك، في قضايا أخرى بتريد إنك تضل.
أردميز شلون؟ أردميز.
نعم.
أردميز.
ما فهمت.
أميز. أميز الدعوة لأن شركة أوبر ظلمتني، شلون أميز؟
بدك تعمل استئناف. So I have a question. I want to appeal. How to appeal?
I am happy to discuss that with you at another time, but not during this meeting, because there are many other people who are just as interested in their own cases as yours. So I can set up a time to talk about that with you separately.
هلا ممكن هي بكل سرور إنه تحدد موعد معك حتى تتناقشوا موضوع الاستئناف. طبعا بس مو هلا لانه هلا في قضايا اخرى بدها تعرض.
انا هسه حغادر وان شاء الله انتظر منها امي.
فاذا انت حتترك هلا الاجتماع الك؟
حترك انا خلص عندي خلص الاجتماع.
اوكي. So yeah. So okay I'm leaving now this meeting.
بس انا منها امير عن الاستئناف. تواصل
يعني I still waiting for you to schedule to set a time to discuss the appeal.
I will be in touch with you after today's meeting, today or tomorrow.
فإذا اليوم أو بكرة هي تحكي معك.
Okay, thank you so much.
Thank you.
شكرا جزيلا ساعدتني بالترجمة.
Thank you all, and he thanked the interpreter also.
And I also thank the interpreter. Thank you, Mr. Bonds.
Thank you, ma'am. Thank you, ma'am. So, do you want me to stay or?
Nope. I believe we do not have any other folks who need Arabic interpreting at the moment. So I think we're all set.
Thank you, ma'am. Have a good day.
Thank you, Mr. Kareem. Thank you, Ms. Lanfer.
Thank you.
Okay, so we have about a few minutes left. We're taking a very short break before we go on to the next case. So we'll be back in about 2 minutes.
I see you, Maura, now.
Oh, good. Okay.
But I don't know why, I guess. But anyway, yeah, I see you.
Okay.
Right now, but there's only one person, the main, whoever's voicing the
So
main
if
voice
she
or-
spotlights Kevin,
I think everybody
that's
will
best.
only see Kevin. I think when she spotlighted before,
no, I have everyone else in little boxes on the top.
even when she spotlighted before, because suddenly there was only Kevin and then suddenly there was only you, but you could still see
She
everybody else.
spotlighted me and Kevin. Like she did one, she spotlighted Kevin and then she
Right.
spotlighted me.
Right, but when she spotlighted Kevin,
Mhm.
you could still see everybody else? Okay, because I don't want, it's
Yeah.
okay if people are staring at
Yeah.
him, but they
Yeah.
may want to see.
The challenge
I
is
don't
you
know.
won't be able to monitor me.
Yeah, neither of us can monitor either of us. So that's the problem.
Do you want to quickly FaceTime and then have that on your phone?
Yeah, I could do that.
And then we can at least see each other?
Yeah.
All
That
right, I'm
sounds great.
FaceTiming you.
Because otherwise the only feeds are through the private
And also,
chat.
interpreters, both Maura and Mary, Melody, if I can hear
One-
one of you saying.
1 second, okay.
If you want to open the public access link on YouTube, which we could forward to one of you or paste into, Melody maybe could paste into this chat, you can see, it's very slight delay, but you can see the facial expressions if that is helpful. I know it's not, it may not be in the time frame that you need for simultaneous interpreting, but it's an option.
Mary, what do you think? Does this FaceTime work to see each other?
Well, FaceTime works.
So I just set you on my laptop in front of the screen so that you're in my,
Right.
And then
know,
I
I'm just trying to think, so if there's a feed or a correction, is it gonna be open? You'll just sign and I'll just sign. Does he see both of us?
I see both of you one on top of the other in the Brady Bunch.
Okay, good. So then if, when we're going with your testimony, if Mary's signing and Maura wants to clarify, then Maura will just start signing the clarification. And then it'll go back to Mary and vice versa. Maura's signing and Mary needs to clarify. So, and if it's not working, let us know.
Okay.
Like right now, I don't see you, Kevin. I only see Maura.
So that's, yeah, so while Kevin is doing his comments, Amy, maybe you could spotlight Kevin and then Mary can see Kevin.
Yep, just tell me when.
But we'll have to keep him spotlighted because during rebuttal, I need to be able to see his face.
Just
If
tell
I'm-
me when.
Okay. We might as well do it now.
Okay,
So
is
you're all set with that part.
that what the interpreter's like, is for me to spotlight Mr.
That's
Mishra?
what we're, yeah, it's the interpreters saying that, yes.
Okay. And then we'll be ready to go?
Yes,
Yes,
Mary,
ma'am.
do you want me to start or do you want to start?
You go ahead if you want.
Okay, so before we do that, the commissioner is going to call the case. And actually, just so you know, we're going to be hearing from the respondent first because there is a recommendation for reasonable grounds. So Mr. Mistral is not going to be speaking yet. You will be interpreting for him, but he will not be speaking yet.
Okay. Thank you. That's fine.
Okay. Sorry, I brought the wrong case up. Just a minute.
Yeah, there were several versions of the agenda that had these in different places.
Right. So what's the number of this case?
This case is PA 190247.
Okay.
Kevin Mishral versus Sue Ellen Richardson, Teresa Riley, and Rumford Community Home.
Right. Thank you.
And the reasonable grounds recommendation is only against Rumford Community Home. This should have been number 2 on the agenda.
Okay. Understand. Thank you.
So is there anybody here for, who we take first, the respondent? No.
Just the only respondent with a reasonable grounds recommendation is Rumford Community Home.
Okay. Is there anybody here for Rumford Community Home?
Yes, I'm Betty Olivier and I'm here for Rumford Community Home.
Go ahead, Betty.
Okay, thank you. Good morning, everyone. And please let me know if I'm speaking too quickly. We object to the recommendation of a reasonable grounds finding against Rumford Community Home on the basis that it adopts an interpretation of the Maine Human Rights Act and the ADA that is far broader than what the regulations permit, and that really has no support in the regulatory language or in any case law construing it. I'm going to begin with a quick summary of the background because the facts are really critical to the analysis here. The complainant, Mr. Mishral, is the son of an individual who was a resident at Rumford Community Home from June of 2017 through October of 2019. Services for residents at long-term care facilities are individualized to meet their needs, and so interdisciplinary team meetings or IDT meetings are held to plan, discuss, and coordinate the residents' care. During the initial several months following the resident's admission to the facility, Mr. Mishral, the complainant, was invited to participate in the IDT meetings, and he was provided an ASL interpreter. But over time, as the resident's care team became more familiar with the resident, his needs, and the family dynamics, it became apparent that it was no longer necessary for Mr. Mishral to participate in these meetings. First, the resident himself was fully capable of participating actively in his own care planning. Second, his wife, and not the complainant, was his healthcare agent. She held both a financial and a healthcare power of attorney, and she too was an active and capable participant in these meetings and in healthcare planning decisions. The resident's needs were being met within the facility. This wasn't a situation where he was going to be discharged home and there might be a need for someone else to participate to assist with follow-up care. The resident wasn't asking that the complainant participate in these meetings. The resident's wife and power of attorney had actually expressed her preference that the complainant not participate because there was a good amount of tension between the two. A representative from the long-term care ombudsman's office had come to the facility, met with the resident, met with the complainant. She determined, after speaking with the resident, that he could communicate with his son. She found nothing suggesting that the resident's needs were not being met. And she shared with Mr. Mishral that the resident himself didn't see a need for him to participate in the IDT meetings and have an interpreter. Based on these facts, all of which they're not disputed, the decision was made that the complainant was not a necessary participant in the IDT meetings, that he need not attend, and that the facility need not provide him an interpreter for those meetings. With respect to the legal standard, it's true that the Maine Human Rights Act and the ADA do require public accommodations to provide auxiliary aids to hearing impaired companions. But this obligation is not absolute, and the regulations make clear that it extends only to companions who are, quote, appropriate persons with whom the public accommodation should communicate. The interpretive guidance to the ADA regulations, and these regulations are very similar to the Maine Human Rights Commission regulations, help define who might be such a, quote, appropriate person. And the guidance makes clear that the focus is on the issue of whether the provision of an interpreter or some kind of auxiliary aid is necessary to protect and further the interests of the individual who's the recipient of the services being provided, and that's the resident in this case. The guidance also provides some examples of when this may be the situation. One such situation could be if an aid is necessary to avoid some kind of a miscommunication that could lead to a misdiagnosis or a delay in treatment. That's not the situation here. Another situation could be if the companion is legally authorized to make healthcare decisions. Again, that's not the situation here. There was a healthcare power of attorney who was making these decisions. Another situation could be if the companion's going to have to help the resident with information or instructions given by healthcare personnel about the resident's symptoms, needs, conditions, or medical history. Again, that wasn't the situation here. There's no dispute here that it wasn't necessary to the proper conduct of the IDT meetings or to the resident's care planning that Mr. Mishral be an active participant in these meetings. And the resident himself made that clear. And because Rumford Community Homes could have simply excluded the complainant from the meetings, it's inconceivable that the law could be interpreted to require it to provide an interpreter simply because it allowed him to attend. This finding really ignores the key facts that I just summarized, and it could have the effect of really turning the law on its head. First of all, it elevates the wishes of the companion over the needs and wishes of the service recipient. Second, in this case, it overrides the determination of the resident's legal healthcare agent, and the resident's healthcare team that the complainant's participation in IDT meetings was not necessary. And third, it has the effect of requiring every long-term care facility to provide an ASL interpreter to any hearing impaired companion or friend who wants to visit a resident, who wants to participate in healthcare planning, regardless of what the wishes or needs of the resident might be. This is just an inappropriate application of the law. There was no violation of the Maine Human Rights Act, the Americans with Disabilities Act, or the Rehabilitation Act here, and we respectfully submit that the commission issue a no reasonable grounds finding. Thank you, and I'm happy to answer any questions.
Sorry, my internet just crashed. I take it that there was no impact on the meeting at large. Nope, okay, good, great. Any questions from commissioners for Ms. Olivier? Commissioner Whitworth?
No questions from me, thank you.
Commissioner Helberg?
Just to be clear, from my understanding, is that both the resident and his wife, who had the power of attorney, said that the complainant was not necessary to these meetings. Is that correct?
That is correct. The resident was indifferent. Mr. Mishra wanted to attend nevertheless. The resident was indifferent, and so they allowed him to attend, but they both made clear they didn't think he was a necessary participant.
So they allowed him to attend, but said he was not necessary to the care plan or anything thereafter. Is that correct?
Right. His active participation was not necessary.
Thank you.
In fact, was contrary to the wishes of the healthcare agent.
Okay. The healthcare agent, was that the spouse of the resident?
Yes.
Okay. And so you said there was tension between the two of them in the record, but that was not defined. Is that correct?
That's correct. Didn't
Right,
provide any details, partially to protect the privacy interests of the resident and his wife.
All right. Thank you.
Commissioner David, questions for Ms. Olivier?
Yes, Betty, you referred to the guidance for Regulation 7.71C1. Is that guidance before us? Is that in the record?
No, it's part of it's part of the ADA regulations. It's written into the regulations.
Is there any specific case law that you think bears on this case in terms? I think we're focusing on the definition of companion as to whether that's being encompassed here.
Yeah, and a couple reactions to that. I think the investigator suggested that we determined that to be a quote companion, you have to be involved in healthcare planning. And that really wasn't our position here. Our position was it's got to be someone who's appropriate and needs to participate in communication. And because these meetings involved healthcare planning, the fact that Mr. Mishra did not have to participate and was not asked to participate in healthcare planning was critical to the decision. In terms of case law, I was not able to find any cases that address this type of a situation involving a companion of a resident at a long-term care facility. The closest case I could find, and this was cited in the written submissions, involved a patient in a hospital. He was terminally ill. He was in and out of the hospital on several occasions, and his parents wanted to have interpreters to participate in a lot of discussions. The patient had actually designated someone else.
Excuse me, is this in the record?
Yes, the case is cited in our written submission. And I was asked to provide information on case law. And in that case, the court's conclusion was that the parents were not entitled to an interpreter because the patient himself had delegated someone else. And there were occasions, even the parents weren't excluded from all conversations, but the determination was there was no need for an interpreter on those facts.
And I have one, I'm sorry, I have one other question, I guess now after hearing this, is that, and I'm not sure if it's in the record, but is there a reason why the complainant wanted to be included?
If it's in the record.
If it's in the record.
I don't believe that it is. I mean, there was an issues and resolutions conference and he might have said something, but I'm not aware of anything in the record that explains that.
All right, thank you.
I wanted to participate.
I was still had another question, Ted. You said that the spouse asked that the complainant not participate, but the resident said he was ambivalent, didn't care, and so they let him participate. Is that an accurate summation?
Yes, it is.
Thank you. That's all from me.
Okay, thank you. And Ms. Olivia, you'll have about 3.5 minutes left after we hear from complainant.
Thank you.
So now we turn to hear from Mr. Mishral. So you'll have 10 minutes unless the interpreting process seems to be slowing down the communication process, but I do not expect it to because the interpreters are fantastic. So 10 minutes. Go ahead, Mr. Mishral.
I'm sorry, one second. The interpreters are choosing it. Yes, so Mary will be voicing the situation. So we're switching over to Mary. Go ahead.
Mary's on mute.
Yeah, Mary's on mute. We can't hear.
I did read the documents that were submitted, and this happened over the last 4 years. I had involved the Disability Rights Maine and spoken with them through BRI, and it was determined that I had a right to have accessibility. And I was in a meeting at that time, thanks to their help, but we were discussing my father's medical needs and nutrition, and there were questions I had, and without an interpreter, I would not be able to participate. So it was deemed appropriate to have at least BRI, though I prefer to have an on-site interpreter. But if there was going to be a problem with getting an on-site interpreter, we would use BRI. And I do know that there is an interpreter who lives very close to the Rumford Community Home, and they could have easily used that interpreter, and it would have saved financially. And so with that process, with that being said, I'm sure that many states allow companions and have amended. Let me find my document. One moment. I have this here from the National Association for the Deaf.
You can't.
Companion. Amy, go ahead.
I was going to say you can't submit new information right now, so you can't show it to us.
I'm sorry. He's not okay.
Yeah. You can't show us new information now. If you already submitted it to the investigator, you can talk about it.
I found this and I did give it to Jane.
Great.
Yes, I had given it to the investigator.
Okay. Sorry for interrupting. Go ahead.
I, at the time, did not realize my mother had power of attorney until after my father had fallen, and I got report of that, and I asked staff what had happened. Why did that fall? And they gave me some written information, and POA was in there, but I did not know what it meant. And it wasn't until later when I learned this term of power of attorney. which my mother held that position. My mother passed away last November of 2019. And my father's doctor suggested that I take on POA, power of attorney for my father. And so I learned more about POA at that point in having to take on that role. But the information is there in regards to a companion, the term of companion. And I don't know of any changes to
23.6.2C.
Interpreters getting clarification on that. 23.1. Interpreter's just not clear what he's referencing. 5M.R.
Section 46132. And then a parentheses 3.
There,
Is
oh,
M-
from the Maine Human Rights Commission or from the investigator, there's all these sections with numbers that they're citing. And I don't understand a lot of those as well. And I do not know why BRI was not used, because that was also an option, and this is why I based my complaint. Non-scheduled and scheduled
incidents.
Things occurred from time to time, and whether they had the meeting impromptu or pre-scheduled, again, they had all the information to access interpreters so that I could participate and that the staff could communicate with me. My family did not sign at all, my father nor my mother. And when I would visit my father and speak with him, basically all we could do really was sit around and look at one another. I really wish they would have set up BRI so Dad and I could have some more heartfelt discussions. And we did, when Dad was transferred to the Rumford Hospital, we used BRI there and found it very helpful. But the Rumford Community Home would not provide that. And that led to the problems we had. I guess I'll stop with that for now.
Okay, you'll have time to say something else after we hear from the hospital. But first, I need to ask our commissioners if they have any questions for you. So Commissioner Whitworth, any questions for Mr. Mistral?
No questions.
Commissioner Hellberg?
A couple. Who determined that the complainant should be a participant in the meetings, and what was the basis for that?
Oh, so you're asking me directly, Mr. Michael was asking. Well, the basis for it is I needed to know what was going on with my dad's diagnosis and his history, and what was occurring regarding his dementia, his Parkinson's and his other health issues. But I was not privy to any of that. And my dad did tell me that he permitted for me to be involved in the meetings, and being involved wasn't just to sit there and be a non-participant, just a breathing body. It was to be involved. I could not do that without the interpretation. So I don't understand why this wasn't made available. Dad gave permission for me to be there to know what's going on. and be aware of his case.
My question is, was he there as an observer or there as an active participant in decision-making?
If I could pause, it would be helpful if you would address your question directly to Mr. Mishral. Thank you.
Mr. Mitchell, yes.
Just one moment.
To
for the
be
interruption.
involved. I think involved means just what it says, involved, not just a stagnant observer, to be involved.
And how do we know that? I mean, that's, to me, was one of the bases of this question is, was he an observer or was he an active participant in decision-making?
Again, Ted, I'm going to ask you to direct your question directly to Mr. Mishral, not about him.
Okay, that's what I'm trying to do. I apologize. Mr. Mitchell.
I hear what you're saying. I definitely wanted to participate. I wanted to be able to ask questions or get clarification and understanding of what was going on with Dad. And so I'm not an observer. I'm a participant. I needed to be there to know, even as an observer, I would need interpretation to understand what's going on. So any way you look at it, I'm there with that need for access.
Okay. My real question, Mr. Mitchell, is this. Who has the authority in that meeting to make decisions?
My understanding, that was Sue Ellen Richardson.
Okay, she's a respondent, so that's okay.
Go ahead, please.
That was my answer. Sue
He just
Ellen
answered.
Richardson.
Yeah. Sorry,
Right.
I'm talking over it, so he did answer.
Okay, so just to be clear, is that the wife of the respondent? I mean, of the resident then, who has the decision-making authority?
Oh, no, she was a social worker of the Rumford Community Home.
I guess I'm confused a little bit then. I thought that the wife of the resident was the legal authority for the resident.
Well, she had POA for my dad, but I was not aware of that, did not fully understand that, that process occurred. And that came about, or I learned about it after my father fell, and I was trying to speak with staff to see what had happened. And the nurse said, "I'm sorry, I can't tell you anything, and here's why." And she gave me this document that listed my mother, who is not Sue Ellen, my mother, as power of attorney for my father. But as for the decision-making of participants or whatnot at the hospital, that would have been Sue Ellen. And they gave me a copy of this POA. But
And
again,
then
at the time,
I
I did
didn't
not
un-
understand it.
I didn't understand what POA meant until after my mother passed away. And then I was reading about this POA and did some investigating. And that's when I understood what POA stands for.
So regardless of the complainant's understanding.
No, you need to direct the question to him.
Okay, I'm trying to.
But you're saying he, when you should be saying you, Mr. Mishral.
You, Mr. Mishral, regardless of your understanding at the time, the POA put another person in charge of decision-making. Is that correct?
At that time, no. I mean, honestly, my mother should have probably been explaining to me what her role had now become. But that was a discussion we did not have. She didn't have that with me. And then I could have known more clearly what was going on and maybe had a role in that as well. But my whole desire, my entire goal was to make sure Dad's needs were being met and Dad could progress and do as well as he could. That was my intent, to know what's going on.
Okay, Mr. Mitchell, I respect that. I'm just wondering, though, still, regardless of your understanding, your mother had the decision-making authority. Is that correct?
I guess yes.
I have no other questions.
Commissioner David, any questions for Mr.
Yeah.
Mitchell?
Yes. How many meetings did you attend that they provided the interpreter for before they stopped doing that?
I would say there were altogether about 7 meetings. I could not attend some of them. They went on with me, they went along with them anyway, I think 3 or 4. And I was making the request for an interpreter, VRI, or live, or on site as we call it. And I was saying the facility has the responsibility to do this, to make this accommodation. And it just wasn't happening. But there were 3 meetings where VRI were provided.
And those were at the beginning of his stay, the beginning of the meetings and his stay at the home, correct?
That's correct.
Do you question whether or not your father and excuse me, I don't know how to silence that.
That's very ironic.
Yeah. Do you agree that your father and I don't know if it's your mother, but and his spouse were competent?
If it's in the record.
I believe it is.
Okay.
Well, when my father's dementia came on and the Parkinson's, as things got worse and more medications he had to take, I don't think Dad's prognosis was good of how well he could heal or function. And then my mother stepped in to help. I wanted to know more of the progression of the disease and what would happen as Dad took that turn for the worse. I mean, there were things that had to be discussed. And
Also that I would be prepared to take over, because as my mother has passed away, I needed that information.
And Rumford Community Home didn't give me any information at all about Dad's status and what or how long to, what his prognosis would be. So I'm honestly, because of Mom's progression of her illness and Dad, I don't know that collectively they did fully understand or could.
I have another question for.
Okay. Can we just let Ed finish?
Yes.
Ed, did you have
And
any?
yes. Did you speak with the ombudsman?
Yes, I did have a conversation with them.
And did
When
that
the
person,
Rumford Community Home refused time and time again to provide services to me, yes, I spoke with the ombudsman and submitted information to them so they would understand the case. And they came down to the home and we spoke with one another, and they spoke with Sue Ellen and explained the policy and the requirements, to no avail. And then there was discussion about possibly moving Dad to another place, I think just to avoid the issue of having to be accessible, provide that accommodation. But they were like, well, let's see if we move Dad or if we move your father, how well he'll do or not. And it did not work out.
the ombudsman explained their decision to you, and it supported the legal conclusion of the Rumford Community Home that they didn't have to provide services. Is that a fair statement?
No, that's not my understanding.
Okay. Was it a written report by the ombudsman?
I responded to the ombudsman 3 times.
Was there a written report? Sorry, I'll ask the investigator.
We were emailing one another.
Okay. Thank you. That's all.
And I believe the information also, Commissioner, would be in the packet.
Commissioner Helberg, did you have another question?
Yeah, just one specific question. Was the complainant, Mr. Mishra, were you on the list of HIPAA eligible information recipients?
Hold on. The investigator is signaling me that that's not in the record.
All right, thank you.
So don't answer that, Mr. Mishra. Okay, so any other questions right now for Mr. Mishra before we move on to, before we go back to Rumford?
None on my part.
Okay. So then, all right, Mr. Mishra, you'll have 5 more minutes after we hear from Rumford. But now we're going to go back to Rumford, to the hospital. We're going to go back to Miss Olivier and say, Miss Olivier, you have about 3 minutes and 30 seconds if you want to use them.
Would like to, thanks.
Sure.
I'll try to address a few of the issues that were raised. With respect to this whole question of whether Mr. Mishra was an active participant in the IDT meetings, the answer is no. The determination was made that he did not need to actively participate. He could have been excluded from the meetings completely. He wanted to attend, so he was allowed to attend, but it was made very clear that he wasn't going to have an interpreter. And that goes directly to the question of active participant. He was not a necessary active participant. There's a team of people. Early on, the resident himself was capable of participating in healthcare planning, and his wife was as well. And those 2 and the other members of the team were the active participants. He also raised the question about not using the VRI. The facility had tried a VRI on some occasions, but they had an internet connection problem, or their internet wasn't strong enough. But that's really not the issue here. The issue is, once the determination was made that he did not have to participate in the meetings, there was no need for an interpreter or the VRI. Had it been necessary for him to participate, they would have provided an interpreter, which they did at earlier meetings. And there was a question asked, I think there were at least 2 meetings where he was provided an ASL interpreter. at the IDT meeting. He's also raised questions about the capability of the resident and the wife to participate in healthcare planning and decision-making. And during all times that were relevant to this case, this complaint was brought in, I think, March of 2019. The answer to that question is yes. I mean, the healthcare team had determined they were capable active participants. The long-term care ombudsman representative had. And it's true, Mr. Mishra left the facility in October of 2019. His wife did pass after that, but these things all happened after the fact. And that's all I have. Again, I'm happy to answer any other questions.
Thank you. Commissioner Whitworth, any questions for Ms. Olivier?
No, thank you.
Commissioner Helberg?
Who determined that the complainant was not an active participant? And if he was allowed to attend, it seems to me that even if he was allowed to attend, he would have been given some kind of help as far as either, ASL or some other active participation so he could understand. So who determined he was not an active participant, and why was he allowed to go in there without any kind of interpretive services?
The resident's wife, who was the healthcare power of attorney, and the resident's healthcare team determined that he did not have to be an active participant. So their option was to exclude him from the meeting. He wanted to attend. He was made aware that he would not be provided an interpreter. And they could have excluded him. They allowed him to attend, but that doesn't trigger an obligation to provide an interpreter, given that his participation was not necessary. And, I do want to point out that the folks at Rumford Community Home, the members of the residents' healthcare team, did try to communicate with Mr. Mishra. They wrote notes, they used handwritten things, and everybody understands that that may not have been sufficient if he were a true participant in healthcare planning, but he wasn't. But people were trying to work with him throughout the process.
Okay, just to clarify then, so he was not designated an active participant. He was allowed to attend, and then there were others who gave him written notes. I mean, because to me, it seems from a courtesy, you'd want him to understand if he was allowed to attend. So was he given written notes during that time?
I think there was some effort to do that. But again, we're talking about a courtesy versus a legal obligation here. And the legal obligation.
I understand that. So I'm saying, but even as a courtesy, he should be allowed to understand.
And there was some efforts undertaken to do that, but I don't think there was any legal obligation here to give him what he needed to be an active participant.
All right, thank you.
Commissioner David, questions for Ms. Olivier?
No, nothing further.
Thank you. So now we'll go back to Mr. Mishra. Mr. Mishra, you have 5 minutes left if you want to use them. You don't have to, but if you want to answer any of the other questions that have come up, you can. You have 5 minutes.
When Sue Ellen asked me to participate, I said yes. And how am I going to do that without communication? And she asked me how, and I said, please get an interpreter or on site or BRI. The first time was in 2017. Yes, as the previous speaker mentioned, the internet did not support BRI. And so the next plan would be to get an interpreter on site, which they did, and that was wonderful. And I needed to know about my dad's medication, his health, some of the terminology that was in written materials that I was being provided with, I didn't understand. So I needed to have that interpreted into my language. And so I could really more fully and accurately understand what everyone's talking about. He was a bit of a complicated case, but obviously having an interpreter is much more clearer to me than trying to communicate in writing. And again, I tried to work with them on the issue of utilizing BRI because they would save money. But even if they did get, you know, an interpreter on site, again, mentioning that we had one fairly close in location to the home. But these issues were rejected. And I do feel that as a participant, call it what you want, participant or observer, you need to have communication to know what's going on. And I have the documents here from the NAD. I did provide those. They weren't looked at. You know, I had no way of knowing what Dad's nutritional needs were, his diet, his meds. And as I said, things got more and more complicated as time went on with Dad, and not having that access to communication, there was no way I could fully understand what was happening with his health care. And I'm going to stop with that.
Okay, thank you. Additional questions for Mr. Mishra, Commissioner Whitworth.
Well, I just want to confirm, I'm just reading one of the notes here in the investigator's report, that the complainant was told, or Mr. Mishra, you were told that you could bring an interpreter, but since you weren't required to be involved, there was no legal obligation for the home to provide the interpreter. But if you chose to participate, you could, but it would be at your own expense. So they weren't prohibiting you from bringing an interpreter. They were just saying that they weren't going to pay for it. I just want to confirm that that's correct.
Well, my response to that would be whether it was BRI or on site. I actually even made an offer with the home to see about splitting the costs, even though personally, according to law, I believe I didn't have to pay anything, but I was willing to go that road initially, and they still did not even accept that.
Okay, but again, as somebody who wasn't required to be there, it wasn't the home's responsibility to provide you with that service.
I think that's the question in the case, Deb.
I know, I'm just reading from the notes here. Right. Okay.
Any additional question for Mr. Mishra?
No, I don't have any. Thank you.
Okay. Commissioner Helberg, questions for Mr. Mishra?
Just one. I understand that, you know, that you wanted an interpreter there, and pardon my ignorance, but I'm wondering why written notes would not suffice.
Well, they were trying to utilize written notes rather than use BRI or anything else because of budgetary reasons, excuse me. Now, my first language is not English. As you're seeing, we're using sign language interpreters. So again, it comes down to what would I understand through written notes or written reports. It's why, as I stated earlier, there had to be an interpreter to interpret the original information because I wasn't understanding the terminology, prognosis, you know, whatever else was provided to me back in the very beginning. It was clear written communication was not going to be a clear, complete access for me. So that's the problem with written notes. I don't understand English well enough.
Okay, thank you. That's helpful because I did not understand that a person whose first language was ASL could not read written notes. So or interpret them correctly.
I'm just going to go out on a limb here and say that it's different for every deaf person. Some people whose first language is ASL are PhDs, and some people have a less comprehensive understanding of English.
All right, thank you. That's helpful, Amy. I appreciate it. That's all I have.
Yeah, okay, thank you. Commissioner David?
No.
Any questions? No, okay. Okay, so that's, we've now heard from both the respondent. I did not ask if respondents Sue Ellen Richardson and Teresa Riley were presenting at all, because I assumed that Ms. Olivier was presenting on their behalf. Ms. Olivier, is that incorrect?
That's correct. I represent all three, and there's no disagreement with the recommendation that the claims against the individuals be dismissed because they played no role in the decisions that are being challenged here.
Okay, I just wanted to make sure I wasn't leaving a party out. So at this point, we would hear from the investigator, which is again, Jane.
Morning, commissioners. My name is Jane O'Reilly. I was the investigator on this case. And I'm just going to walk through.
Jane, can you just hold on one second? We're going to switch interpreters. I want to make sure Mr. Mishral can see me. So it's.
Sure.
Okay, all set. Thank you for that.
Great. So again, good morning, commissioners. My name is Jane O'Reilly, and I was the investigator on this case. I'm just going to walk through a couple of issues. The first, I want to clarify this issue with the ombudsman's investigation. Was my understanding, and I have some of the communications, email communications in front of me, that the ombudsman was there to investigate Mr. Mishral's communication with his father only. The investigation was not into whether or not the IDT meetings were accessible to Mr. Mishral, but whether or not the facility was providing enough aid to help Mr. Mishral communicate with his father. And the investigation found that there was no difficulty. Mr. Mishral and his father were able to communicate fine without any assistance from the facility. So I just want to clarify that that was separate from whether or not this issue in the case, whether or not there was an investigation, or whether or not there was a requirement for there to be an interpreter in these IDT. Secondly, I want to go through quickly factual.
Excuse me, Jane, may I just ask for a clarification on that?
Sure.
So there's a separate issue of whether or not he was able to communicate with his father, not in the individual development plan.
There was, not in this case. That was not what Mr. Mishral brought his complaint on at the commission, okay. But that information about the ombudsman was part of the record.
Okay.
He had no discrimination based on his communication with his father.
All right, thank you.
You're welcome. So the second issue, there's been lots of questions about these IDT meetings.
Wait, Jane, just a second, excuse me. Somebody has a dog barking in the background. Could everybody who's not talking, please mute? Thank you.
Yes. It might be one of the interpreters.
I think it's gone now.
I think it's Mary McKay.
Yeah.
I think we're good. So these IDT meetings, they're designed based on the interview I had as part of the Issues and Resolutions Conference, was that the IDT meeting is a meeting for the care team at the facility and anyone that the resident designates to participate in this interdisciplinary meeting regarding the resident's care. So it was not a designation based on necessary individuals to make decisions about medical care, but anyone that the resident designated was appropriate to learn about the patient's care. Who attends these meetings is entirely up to the resident, which I do believe was clear in the presentations that were made today. So then moving into this issue of whether or not Mr. Mishral's participation in this meeting was adequate. I want to point out that Attorney Olivier has used the word necessary many times in regards to the legal complaint. That was true in the respondent's submissions as well. However, necessary does not appear in any of the regulations regarding companions. On page, let's see which page. On page 2 of my report is the commission regulation regarding companions. And it says an associate of an individual seeking access to the goods, services, and facilities who is an appropriate person with whom the public accommodation should accommodate. So it's not necessary, but appropriate. And then looking at respondents' submission of disagreement where they cited federal guidance, the companion is an individual designated by the patient to communicate with personnel about the patient's medical history, symptoms, needs, and condition. That's on page 3 and the first paragraph. So again, the designation was appropriate or someone that the resident had designated. And I found that by saying that complainant could participate in these meetings, complainant was being designated as an appropriate person for the medical personnel to communicate with. Again, that's only the first step in the analysis that I performed in my report, determining whether or not complainant was in fact a companion by definition. And then the second was to get to the issue that you brought up, Ted, regarding the whether or not other methods of communication would have been sufficient for Mr. Mishral to understand what was going on in these meetings. And I found in my communication with Mr. Mishral throughout the investigation, there was a significant difference between his ability to understand and communicate when using an ASL interpreter and whether or not he could understand and communicate using written forms. It was very obvious to me in the commission, the interviews we had versus emails I shared with Mr. Mishral or his written submissions. And by not allowing him to come, by not allowing him the aid, I found in my report that it was he would not have been able to understand what was going on in those meetings and would not have been able to really participate in them at all. Once again, going back to the issue of the companion, the fact that he was designated to be in the meetings, I found established him as a companion. Two just final points. Attorney Olivier also mentioned that this would be an undue burden on the facility if they had to provide an interpreter for all access to the facility. In my report, again, I mentioned that is not true, that these IDT meetings were a specific isolated issue, that they did not and do not provide ASL interpreters for Mr. Mishral simply to access the facility, speak with the nurses, and speak with his father. So the issue of that sort of opening up all interpretation at all levels, I found was not the case. And I believe that's it. And I'm happy to answer any further questions.
I keep muting myself and then unmuting. Questions, Commissioner Whitworth, for the investigator?
I don't have any questions. I just want to say, Jane, thank you for all of that. That was very helpful. I appreciate it.
Commissioner Helberg.
I just want to ask a question for clarification, make sure I understand, Jane. So the fact that he was allowed in to the meeting basically made him a companion? And
sorry.
And because of that, then they were required to provide some type of interpretation. Is that correct?
Yes, so the facts that I found supported based on the definition of companion in our regulations, that he was an appropriate person for them to communicate in the IDT meetings. And then I further found that the only way for Mr. Mishral to actually be able to understand these meetings would be through a VRI, the video interpreting, or an ASL interpreter.
All right, thank you very much. That is very helpful.
Commissioner David, questions for the investigator?
Who called for the ombudsman?
Mr. Mishral.
And you say that that investigation concluded with the conclusion that there was no problem with him communicating with his father, correct?
Yes, and I asked him again about that in the Issues and Resolutions Conference. He said that even though his father doesn't sign over the years, they've been able to develop a way of communicating with each other, and he didn't have any further complaints about his ability to communicate colloquially with his father.
So why doesn't his father designate him as an essential person that's making decisions?
I can't answer that. That was a
Well,
person.
Jane, in your presentation just now, it seemed to me that you went from him being an appropriate person to be there to being a designated person, but he's not designated by anybody.
Designated to be in the meetings,
By
not
who?
designated to make medical decisions.
Designated by who?
Himself.
By himself?
Father.
Okay, one person at a time, just for the interpreters.
Yeah, sorry, I can't see the commissioner's faces. So
But it seems as a designation, as I understand it, is not a formal proceeding. Was the wife designated in some way? She's there because she has a power of attorney.
I think I'm confused as to whether or not you mean designated as someone to make medical decisions or someone designated as a person who is allowed to attend IDT meetings. What designated do you?
Well, that's your conclusion that he's appropriate to be there, therefore he's designated, therefore he's entitled to services. Isn't that your reasoning?
Correct. So everyone who's allowed to be at an IDT meeting doesn't have to be a person who's allowed to make medical decisions. The resident can have any individual that they want to learn about their care come to these meetings.
I agreed. Anybody that's allowed to be there doesn't have to be a person that's designated to make decisions. The question is whether the facility has to provide interpretive service for anybody that's allowed to be there, that doesn't have that designation and doesn't have any authority. And I don't see where that comes from. You say that the complainant meets the definition of companion. Well, companion is a person that the facility has to communicate with. And I agree that it's not necessary that they have a formal power of attorney, but could be informal, but whatever's going on in the family dynamics here leaves the spouse with the legal power and not him. And he has no problem communicating with his father. The ombudsman says that. And the father has solved this problem, saying, no, he can be here, but he's not designated to make decisions.
Correct. So maybe I can wait and see if you have a question related to that. My response would be that you've outlined the issue correctly. I think you disagree with my my conclusion. Basically, the best way I can make an analogy, I guess, is that complainant, his father had said, yes, you can attend these meetings if Mr. Mishral was in a wheelchair. And his father had said, you can attend these meetings, but they're on the second floor of this building that doesn't have ramps or an elevator, and no one's going to help you get there. We can't move them. The facility would likely be under an obligation to provide. I mean, that's where I sort of looked at the accessibility of these meetings. He could be in them, but he effectively was excluded from them because he couldn't understand what was happening based on his own communication. So I don't know if that helps.
That's all.
Thank you. Any other questions for Jane before we let her stand down? Okay. Okay, thank you. Thank you, Jane. So at this point, we've heard from both of the parties. I'm going to unspotlight Mr. Mishral at this point, if that's okay with the interpreters. Okay, so I think I just did. The question, so at this point, we need a motion or motions.
I'll make a motion. I'd like to take them separately. And I'm going to do this so that we can get into some discussion with the commissioners. First, I'm going to recommend that we uphold the investigators' recommendation that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability, and this portion of the complaint should be conciliated in accordance with the act.
Is there a second?
I'll second the motion.
So this motion has been seconded. Is there discussion?
Okay, I would like to respond to that since I made the motion, in that actually listening to the investigators, to Jane's understanding and explanation, I've actually changed my mind on this because I'm thinking that anybody who is allowed into the meeting, whether they have decision-making or not, which is what I had focused on in the original discussion, anybody who's allowed into the meeting that's designated, whether they have decision-making authority or not, should be allowed the services for interpretation. And evidently that was not done. So that's the reason that I'm making that motion.
And everything that Ted said, I'm right along with him, that Jane's further explaining what went on in the investigator report that she provided was extremely helpful, and has moved me to change my opinion.
And I have not changed my opinion, which was, I think, Ted, your initial opinion. There's an ombudsman's report,
right,
who is investigating this. I don't quite understand the distinction Jane makes about saying that, well, that report only investigated whether or not he could communicate with his father, but that's enough. If he can communicate with his father and his father's competent to make the decision, and his father has made the decision, and his father has made the decision when specifically asked and interrogated about who's essential here, who's making these decisions. We've been providing these services, as I understand it, for the first couple of meetings, and then the father saying, no, the spouse has the power of attorney and has a healthcare directive, I think was mentioned also, to make the decisions. And I think to expand this to say that it's the fact that he says, sure, my son can be there, whatever family dynamic applies there, that's fine. He can say that I want him in the meeting. That doesn't obligate the medical provider to go to that expense if he's not an essential person. If he's not a companion in the legal sense of a person that they need to communicate with because he has authority. It seems to me he could designate a number of people and you'd have the facility being obligated, and he's not being prevented from bringing his own method of interpretation at his expense. The question is the expense, and it comes down to that definition of companion. No one's given me any clear case law that convinces me that a person in this non-legal category that Mr. Mishra is with his father, of not having any authority, necessarily incurs the obligation to demand that expense. He said that he wanted to know what was going on with his father, and then he said, and therefore he needed to know. Wanting to know is not needed to know in a legal sense of incurring somebody else's financial ability. I'm troubled by it, but I need to vote against the motion.
I just want to make another comment. Originally, Ed, that's exactly where I was. Okay. However, I believe that it's not an undue burden on the organization to provide an ASL interpreter. And even though they could communicate together, the father and the son, I think that it's the obligation, if they allow the person to come into the meeting, to provide some interpretive services so that everybody who's attending in the meeting could understand what was going on. That's all I have.
But it's not the home's obligation to exclude people. The fact that they're recognizing the patient's desire, saying, sure, let my father come. But that's not, allowing doesn't mean that therefore they, well, that's the question. Okay.
Well, but when to me, when you allow, it's almost like discrimination. Did you know or should have known? Well, obviously they knew that there was a disability there, and that it would be helpful to have an interpretive services there. So again, that's where I'm coming from, and I respectfully understand, but disagree with where you are coming from. I've changed my mind on it because originally I was where you were.
Doesn't that mean that what the home should have done would exclude him because he wasn't legally necessary?
They could have done that, and then that would have been fine.
They could have, and I don't think that would have been fine. I think that would have been unnecessary.
No. When I say fine, what I mean is they had
legally fine, right?
Legally fine, but once they allowed, then I think they should have provided that interpretive services.
Accommodating the family and saying he can be here doesn't to me incur that financial obligation.
Understand. I just don't think it's an undue financial burden at all. That's all I have to say.
Me too.
So, sorry. Any further discussion before you call for a vote? So the motion is to find reasonable grounds to believe that discrimination occurred against Rumford Community Home, not against Ms. Richardson and Ms. Riley. So all commissioners in favor, if you raise your hand and say yes.
Yes.
So 2. All those opposed, raise your hand. And no.
No.
So it's 2-1. The motion passes. And so that's the first, I think there are 2 here.
Mm-hmm.
So that is on the first point. Is there a motion on the second point?
Yes, I'll make the motion that there are no reasonable grounds to believe that Sue Ellen Richardson and Teresa Riley discriminated against a complainant on the basis of disability, and this portion of the complaint should be dismissed in accordance with the act.
Second.
It's a motion, it's been seconded. Is there any discussion on this second point? Hearing none. So all those in favor of a finding that there are no reasonable grounds to believe that Ms. Richardson and Ms. Riley discriminated against Mr. Mishral, raise your hand and say aye. 1, 2.
Aye.
Aye.
Thank you. So the finding on the latter point is no reasonable grounds. So there's a split decision, reasonable grounds on the first point, no reasonable grounds on the second. And the commission will send both parties a letter outlining the next steps. I appreciate everyone's patience. Do commissioners want to take a brief break before going on to the next case, or just go into it? Hearing nothing.
2 minutes.
Okay. 2 minutes. Just like my daughter used to say, 2 minutes. So we'll be back in 2 minutes.
Can we clarify with Mr. Mishral if he will be continuing to attend?
Yes, please do. I was going to say, Mr. Mishral, you are welcome to stay so long as the interpreters, well, you're not welcome to stay as long as the interpreters are available, but you're welcome to stay. Let me know if you want to continue listening and watching at the meeting. Not listening, watching. You're also welcome to go.
Oh, Mary can't see Mr. Mishral, so let's just see. And Mr. Mishral saying, I have things to do, so I'll be leaving. Thank you very much.
Okay, thank you very much, Mr. Mishral and Ms. Olivier, and thank you to the interpreters.
I wanted to say my thanks as well. It was muted.
Thank you.
Thanks you.
Oh, I just realized I was muted all through that. So thank you, folks.
Thank you.
I'm clicking leave, but I'm still here.
Just like you couldn't get in, now you can't get out.
I couldn't. Hotel California today. What? I'm going to try to leave. Bye.
Okay.
If I can't go, you can kick me out.
I'm muting you anyway, Mary. Bye. We're friends. That's okay. Well, we're friendly. Okay. I see 1, 2, 3 commissioners. Where did my counsel? There she is. Okay. We'll wait for Commissioner David and Commissioner Hellberg to come back. And just let me say thank you to the other folks who are waiting patiently. I understand this has been longer than usual to get through cases. But that's why we take the cases with interpreters first.
What will be next? Do you know, Amy?
What should be next, I think after that, we're going back to whatever the agenda said. So I think next should be E180348, which is Thomas Mikdewitz, which I'm sure I have mispronounced again, and the University of Maine system.
That's Mikadowitz.
Mikadowitz, thank you, and I apologize.
No problem.
Okay, we have 3 commissioners. I think we can probably get started, and I know Barbara will be back in just a second.
All right. Case E180348, Thomas Mikadowitz v. University
Yes.
of Maine system. Is there anybody here for Mr. Mikadowitz?
Yes, Philip Johnson, representing Professor Mikadowitz.
Okay, Phil.
Thank you. I wanted to go over the factual background of this and then explain why we disagree with the recommended decision from the investigator. Professor Mikadowitz he's 69 years old. He's a professor of theater, or was a professor of theater at the University of Maine. He'd been with the university since 1988. He was tenured in 1996. He achieved full professorship in 2005. And throughout his career, he always received favorable evaluations and raises from year to year. In October 2016, he directed a play called Big Love. And this is a play that was based on a Greek tragedy. It had sexual content in it. However, it was well respected nationwide among other colleges, and was also approved by the theater department at the School of Performing Arts at the university. After he directed this play, he was the victim of an allegation of sexual harassment. The university hired an outside investigator to come in and investigate it. This is an attorney who specialized in employment law. And at the end of the investigation, the investigator found that there was no reasonable grounds to believe that any sexual harassment had occurred. However, she also concluded that she thought he exercised poor judgment in his direction of the play. And as a result of that, the matter was referred to the Department of Human Resources for further investigation. And that referral was made on June 12, 2017. Professor Mikadowitz was advised that Human Resources would hold a fact-finding meeting with him. it took forever for that fact-finding meeting to be scheduled. And in fact, it wasn't scheduled for 5.5 months. So, which indicates this was not an urgent matter for human resources. But before the meeting actually occurred, it was canceled because a second allegation was made against Professor Makatowicz. And as a result of that allegation, he was placed on paid administrative leave, and the university also conducted an investigation. This time it used one of its internal investigators to investigate the allegations. At the conclusion of that investigation, there was a finding of no reasonable grounds upon which to believe that Professor Makatowicz had violated any university policies. However, the recommendation was made on May 17, 2018, that the matter be referred to Human Resources because students had complained that Professor Makatowicz was, and this is in quotes, insensitive to their opinions and their concerns regarding the content of his plays. So as a result of that, another fact-finding meeting was going to be scheduled. In the meantime, before this fact-finding conference took place, on May 24, 2018, Professor Makatowicz was taken off administrative leave and told he could return to his full duties as a professor of theater. He was welcomed back to the university. There was an informal gathering where he was welcomed back by other professors. The dean was supposed to attend that, but she did not. And the next thing that happens is on August 30, 2018, he gets a letter from the dean, Emily Haddad, that he's again being placed on administrative leave for possible further investigation and disciplinary action through a fact-finding process. So that's what precipitated the scheduling of a second fact-finding conference, the first not having taken place. In the meantime, on September 20, Professor Makatowicz filed a complaint alleging age and sex discrimination. The basis for his complaint was that one, he was 69, that another professor about his same age was in the process, so to speak, of being disciplined or terminated by the university. He had not yet been terminated. And secondly, that a younger adjunct female professor had been brought into the university and appeared to be taking over some of Professor Makatowicz's responsibilities. There was also another female who was involved in the theater department who appeared to be taking over some of his responsibilities. So this fact-finding conference gets held on October 19, 2018. But no reports ever issued by the committee that held the conference. In the meantime, when the discrimination complaint was filed with the commission, it had been sent to the university, but no response had ever been filed. So on November 21, 2018, the complaint is mailed a second time by the university to the university by the commission. And at that occasion, the president acknowledges receiving it. 2 weeks later, the president abruptly terminates Professor Makatowicz for an alleged pattern of inappropriate and unprofessional conduct towards students and colleagues. That, in our view, was pretense. And why was it pretense? It was not this was not a legitimate non-discriminatory reason for terminating Professor Makatowicz. And the way we know that is because the university had a written policy concerning progressive discipline, which ranged from first meeting with the professor to discuss problematic issues, a second step being to issue an oral warning to the professor with appropriate coaching. The third being issuing a written warning to the professor with coaching. The fourth being suspension without pay, and then the final being termination in the event the misconduct, so to speak, continue to occur. Well, none of the steps were followed in this case. Professor Makatowicz was never provided any coaching in the first instance. He was never given an oral warning. The matter was simply referred for a fact-finding conference, the first of which was never held, and the second of which was held, but no report was ever issued. And in the history, in Professor Makatowicz's experience, in the history of the university, no professor, no tenured professor had ever been abruptly terminated in this fashion. And it so happens that about the same time Professor Makatowicz was terminated, however, another professor of about his same age was also terminated. And this was after both professors, over a period of a couple of years, had been encouraged to retire by the university. So in this case, we respectfully ask the commission to find that there are reasonable grounds to believe that unlawful administration or unlawful discrimination occurred because Professor Makatowicz presented a prima facie case by showing the temporal relationship, the 2-week period between the filing of his complaint with discrimination and the date of his termination, and that there's no legitimate non-discriminatory reason for that discharge. The president of the university wrote Professor Makatowicz a letter stating reasons for the discharge, which included touching a student inappropriately without consent. Well, there had already been a finding that he did not engage in any sexual harassment or that he violated any university policy. By making off-color remarks regarding female students, there had been no finding of that. Being dismissive of female faculty and engaging in inappropriate conduct during class evaluations. Those are matters which, if they did occur, would certainly under the university's policies have warranted some initial coaching. And then if that coaching didn't work, then an oral warning with coaching. So that, as we respectfully request that the commission find that there were reasonable grounds. We also believe that Professor Makatowicz has a firm case on both sex and age discrimination, but for today, the most clear example of the unlawful discrimination is the discharge in retaliation for filing the Maine Human Rights Commission complaint. Thank you.
Precisely 10 minutes. Very impressive, Mr. Johnson. Questions for Mr. Johnson, Commissioner Whitworth?
Nope. Questions. Thank you.
Commissioner Helberg.
Is it your contention then that the university did not follow its prescribed disciplinary action, just to be clear?
It absolutely didn't. It didn't follow any of it.
Okay. The other question I have is on you said the interpretation of this play, Big Love,
yes,
was a part of the discrimination against your client. So tell me how that happened. I mean, I'm assuming that's in the record too.
Well, during the course of this play, a student participant in the play had the impression that Professor Makatowicz had inappropriately touched her in directing the play. And there may have been some contact there, but it was not sexual in nature, certainly as far as Professor Makatowicz was concerned. That was the allegation, the primary allegation that was investigated by the outside investigator, and the investigator found that there was no reasonable basis to believe that Professor Makatowicz had engaged in any sexual harassment, which was the allegation made by the student.
But isn't the law interpreted as it's not the intent but the effect on the person? And if so, why would you not give credence to that?
Well, the investigator found, if I'm recalling the report correctly, and I do believe I am, that the student did not actually perceived this as as having any sexual intent behind it. I mean, she said it was a touching. Professor Makatowicz was unaware that he touched her, but she said that she did not believe that it was done with any sexual intent.
At this time, that's all the other questions I have. I think I'll have a couple more afterwards, but thank you.
Sure. Commissioner David.
Phil, what is the force of being a tenured professor? Is that what, I think I know the answer. You tell me if I'm wrong. Is that what triggers the progressive discipline and those entitlements as opposed to just being dismissed without at will? Is that?
As I understand the policy, any employee of the university is entitled to the rights under progressive discipline. What makes Professor Makatowicz's case even more compelling is that he wasn't simply an employee, he was a tenured professor, which takes greater grounds or more extraordinary grounds to terminate.
Are those formalized, those greater grounds? Can we see what they are?
Not that I've seen in any documentation. The only documentation we have, which is part of the record, is the progressive discipline policy of the university.
And referring back to that incident with the student in the first play and the touching of her, I can understand that the report said there was no sexual harassment, because that I think requires some intent. The student said she didn't perceive it as sexual in intent, but it certainly could have been very inappropriate without warning and touching her body. And you would agree that could be inappropriate, right?
I agree absolutely that it could have been inappropriate. And if we assume that under the progressive discipline policy, what the university should have done is sit down and talk with Professor Makatowicz about his direction of the play, discuss the problem with him, and allow for corrective action. It never did that in this case.
What do you do with the 20 students in the boycott? That seems to me to be dramatic.
Well, it's dramatic, but they all sent a common email, or they joined in a common email, and certainly it's dramatic, but does that justify the abrupt determination of a tenured professor?
What were they complaining about?
They were complaining about his, I guess the way he conducted the class. They claim that he was insensitive to their opinions and concerns about the content of plays. I can fully understand students having concerns, or that or their opinion of a play may be such that perhaps the university shouldn't use that play in its curriculum. But in this instance of Big Love, that was a play that was approved by the theater department, and it was a well-respected play around the country. So certainly if students can have a problem with that, and if that's the case, then it involves the department making decisions concerning future plays. Okay, we're not going to do this one because it may present a problem for our students, but it just simply doesn't justify a termination under the university's policies.
Was the email and the 20 students in relation to that play, that specific play?
I believe it was. I can't tell you whether there was a relationship between that and the first play.
Okay.
I think there was, but I can't say that definitively.
Thank you.
I have one other question, Amy.
Yeah.
So, Mr. Johnson, on your response on page 6, you say also prior to terminating both men, the university had been encouraging them to retire so they could bring in younger professors who would be paid at a lower rate. Is that correct?
Yes.
Okay. How do you substantiate that? I mean, I don't understand that.
Well, there's the example of the younger female adjunct that was brought in that took over.
Was that based on qualifications, or why was that decision made? Do you know?
We don't know. We don't know. All we know is that it, in fact, occurred. In terms of encouraging retire, all I can tell you is that over a period of a few years, Professor Mikotowicz, and I believe the other professor, received memos or correspondence from the university, which seemed encouragement to retire.
Excuse me, was this in the record? I mean, other than your response.
No, Mr. Strzok is shaking his head no. Mr.
Yeah.
Beauchesne is shaking his head no, I believe.
Right. Okay. Because I know it was in his response, but that's in the record. His response is. So
Well,
is it fair to continue this line of questioning, Amy?
It is not. And I thank you for catching that, because sometimes I don't always catch that.
Okay. Thank you. That's all I have.
Okay. So then we would turn to Mr. Strzok on behalf of the university.
Hi, everyone. Can you hear me? Thumbs up if you can hear me. Okay, great. Appreciate that. My name is David Strzok. I am representing the University of Maine system in this case. Before I get into my substantive remarks, I just want to make one point clear that may have been confusing in Mr. Johnson's presentation. The university had no problem whatsoever with the selection of the material, the Big Love play. The professors have academic freedom to choose the material that they want to teach or direct. And the university's problem was with Mr. Mikotowicz's the manner in which he directed the students in the play. So I just want to be very clear that the subject matter of the play was not an issue in this case or with Mr. Mikotowicz's discharge. This case has a very long history, and Mr. Johnson did a great job walking through the chronology of events. It dates back to April of 2017 when the original complaint came in from the student regarding the Big Love production. And you have that in the materials, and you can see the clarity in which the student made allegations about what conduct was concerning to her and what conduct she felt was inappropriate. The first investigation found that there was no violation of the EO policy under the university's procedures. However, it didn't mean that Mr. Mikotowicz's conduct was appropriate. And the third-party investigator very, very clearly said that she believed that the conduct of Mr. Mikotowicz was inappropriate, in very poor judgment, and it had embarrassed unnecessarily a student. And so the common procedure is if there's not a technical or an actual violation of the EO policy, then the misconduct, if there is any, is referred to the Human Resources Department for a personnel decision. And in the university system, there's two very distinct procedures, one being the EO or equal opportunity, and the other being the HR process. As it moved over into the HR process, a fact finding was scheduled for December 2017. That was taken off schedule at Mr. Mikotowicz's request because he wanted additional information. There was a process to get that information to him, and so that fact finding was tabled. While that fact finding was tabled, additional allegations of misconduct came to the university, and a second investigation was initiated. That report was completed in May 2018. Again, the investigator found that the allegations individually did not rise to the level of sexual harassment based on the severity and the impact to the students involved. However, again, the investigator, which was a different investigator in the second report, found that there was serious concerns of misconduct and referred it to the Human Resource Department. At that moment in time, the EO investigation was concluded, and Mr. Mikotowicz was put back or taken off, I should say, administrative leave because the EO investigation was concluded, and there was a gap between the EO investigation and the referral to the HR department who took over the matter. It was during that gap that he was taken off administrative leave. Once the university HR department took over the matter in substance, he was put back on administrative leave. There's also an explanation in the documentation that gap in the administrative leave happened during the summer, which traditionally in the academic world, there's not a lot of activity during the summer or face-to-face contact with students. Once the HR took over, there was another fact-finding scheduled, and this one was actually conducted. And in all of these different procedures, the fact-finding, the investigations, Mr. Mikotowicz had the ability to be interviewed and to provide information. And the end result is that the university determined that there were credible evidence of serious misconduct. And I think that's where the university and Mr. Mikotowicz disagree, that the information, that credible information the university had showed very serious, egregious misconduct. And Mr. Mikotowicz says it's not severe and it should just be an oral warning. We just fundamentally disagree. And the progressive disciplinary policy is not a lockstep procedure. It provides the ability for the university to accelerate the discipline based on the severity of the conduct. And in this case, we found the conduct to be extremely egregious and justified immediate termination. One of the things in the report, which I think is important to know, is that under the university contract with the union who represents Mr. Mikotowicz, the decision is, there's a decision whether or not to fire somebody immediately or to provide for 6 months severance. In this case, the university decided to terminate immediately. That triggers a automatic review by a faculty review committee. Members of the faculty who are the peers of Mr. Mikotowicz. That actually occurred, and the faculty review committee upheld the immediate termination of Mr. Mikotowicz. So not only did 2 investigators find his misconduct, the university found that there was misconduct, and the faculty review committee upheld that immediate termination. With regard to the actual claims of age and gender or sex, there's really very little, if any, evidence to show that there's anything even resembling age discrimination. The commissioner picked up on the comment that really the only allegation that they have put forth for age is that there's been an encouragement to retire. And as you heard Mr. Johnson say, that there was correspondence sent to the complainant that he interpreted to be an encouragement to retire. There's been no evidence whatsoever that the university in any way encouraged Mr. Mikotowicz to retire based on his age. And there's just simply no evidence. With regard to sex, Mr. Mikotowicz refers to other professors taking on responsibilities. Of course, other professors had to take on responsibilities. He was on administrative leave, so somebody had to take on those duties, and it fell to a female adjunct professor at the time. Lastly, there was a question about the 20 students and the concerns that were raised via email. That was 20 students saying that they refused to even try out for a production that Professor Mikotowicz was considering doing. The students said, "We will not participate in that production if Professor Mikotowicz is involved." And so it didn't arise from the big love, but it arose from Professor Mikotowicz's general interactions with students in the department. I believe I've covered everything. I tried to talk quick so I could save some of my 10 minutes. I know Amy's keeping track.
I am.
I appreciate the opportunity. Thank you.
You have tons of time left, but thank you. Questions for Mr. Strzok? Commissioner Whitworth.
Yeah, only if this is in the record. Is it typical of the University of Maine system to use student feedback when evaluating the job performance of a professor?
I think there's two answers to that. One is in the normal course, there is student evaluations, and student evaluations are used by the university as part of the process for a performance process. But in this case, this was not student feedback. This was students complaining of misbehavior. And if you look in the reports, the first report is the individual students' allegations. The second report, which is Exhibit J, it contains bullet points of many students and what their complaints were under the EO policy.
Thank you.
Commissioner Helberg?
Seem to rely upon, the principle of severe and pervasive for a large part of this. And yet, my understanding, and correct me if I'm wrong, is that during the course of progressive discipline, there were several times where the complaints were dismissed or there was no grounds for disciplinary action. So how do you reconcile that?
I believe what the reference is in the sense of if there were no grounds for the action. I think you're referring to the fact that there was no grounds under the EO policy to, right. Well, as I say, there's a fundamental difference between misconduct that violates the EO policy and misconduct that violates the normal standards of conduct that the university expects of professors. So, for example, the first student's allegation was that Professor Makatowicz touched her inappropriately as he guided her through a scene. Now, the EO investigator found that that was not, did not constitute sexual harassment under the sexual harassment policy. However, when it's viewed as outside of the EO policy, the professor did not request permission to touch the individual. The individual was felt as though the touching was inappropriate. So it may not have been an act of sexual harassment, but it was an act of misconduct that the university expects professors to act a particular way when they're instructing theater students in a physical way.
Why did the university suspend, bring back a couple of times this professor if his actions were so egregious?
Sure. There was one time he was taken off suspension and put back on suspension. So he was taken off suspension in May 2018 and put back on suspension in August 2018. When he was taken off, I say suspension. I use that as a shorthand term. I should be more precise. It's administrative leave. It's not suspension.
Yeah,
I don't want to.
I understand that. Yeah.
Okay, I didn't want the connotations of
I understand that.
suspension. Yeah. So he was taken off He was taken off administrative leave because the EO investigation had concluded, and there was a gap in time until HR took up that referral, and HR made the decision to put him back on leave. I think the factors in the record that, and they came up in the fact finding that were in play was, one, it was during the summer, and so the chances of the professor interacting with students in an in-person way were substantially reduced. Two, the the professor was about to start the new academic year, which included providing instruction to high school age students. And there was a concern that they needed to take action before that started based on the allegations that had been made. And three, there was, I'm sorry, I lost my third point. So the 2 points are the 2 points that are in the record. I'm trying to think if the other one's in the record, and I'm not sure. So I don't want to raise that.
Okay. I may have other questions in a few minutes, but go ahead.
Thank you, Commissioner. Commissioner David.
Would you direct your attention to the retaliation? Could you have a retaliation, sustain a retaliation complaint, or could we, in your view, even if there wasn't reasonable grounds to justify the discharge? I mean, it's only
Is that directed at me?
Yes. Yes.
Yeah. So you know, as this process unfolded, there was a very clear process of being referred to HR. HR took on the responsibility. There was a fact finding scheduled, and then a decision made. During that process, which is an established process, there was the Maine Human Rights Commission complaint filed. There's no indication, and the decision maker testified at the fact finding very clearly that the Maine Human Rights Commission charge played no role in the decision to discharge the individual. And you know, what I would say is that what Mr. Mrkotowicz is attempting to do is use the commission filing as a shield, and to say, basically, if I file a commission charge, I should have some sort of immunity against discipline, when in fact, that's not the case. You know, he was disciplined because he was engaged in misconduct. The fact he filed a charge should not prevent an employer from moving forward with discipline simply because he filed a charge.
Thank you.
I would also ask Mr. Strzok, the timing is suspect as well, isn't it? I mean, how long was it between he filed the charge and termination? Like 2 weeks or something?
I believe it was 3 months.
3 months?
I believe the charge was filed September 27th, 2018, and the decision to discharge him was made December 5th, 2018.
Okay, with knowledge that the complaint had been filed. Is that correct?
The university was aware that a Maine human rights charge had been filed when the decision to discharge was made, yes.
Okay, thank you. That's all I have.
Thank you, Mr. Strzok. And complainant used all of their time. So at this point, we would turn to the investigator, Mr. Beauchene.
Can everyone hear me?
Yep.
Yes, okay, thank you.
Yes.
Good morning, commissioners. Just to briefly summarize a few points in this case. As you are aware, a female student alleged the complainant had touched her breasts and buttocks during rehearsal of a play that called for a male actor in the scene to make that contact with her body, which she had consented to. Although complainant denied grabbing the female actor's breasts, he stated during the initial outside investigation that he may have touched her buttocks due to his close proximity to her while demonstrating how he wanted the male actor to perform the scene. The respondent, in my view, was motivated to discharge complainant because of his age or sex. It appeared to me that they had sufficient justification just based upon the admitted contact that he admitted he had made with her buttocks, admittedly without her permission or providing any notice beforehand that he intended to do that. I think they obviously had even stronger ground since one witness to the interaction stated that he had seen complainant grab the female actor's buttocks and, quote, vaguely remembered him grabbing the female actor's breast as well. Although the outside investigation did conclude that complainant's actions didn't rise to the level of sexual harassment as either quid pro quo or under a hostile education environment, the investigator, quote, concluded that he exercised very poor judgment in his physical direction of the scene and his conduct violated generally accepted professional boundaries, regardless of whether or not there was any sexual intent. The following semester, as the commissioners had touched upon, approximately 20 students, both male and female, sent an email to the chair of the theater department stating that they were essentially boycotting complainant's upcoming spring play, again, due to, quote, complainant's consistent misconduct as director. And this involved not only the interaction with the female actor we just described, but apparently claims that he was dismissive of their opinions, spoke harshly when giving acting directions and things along those lines as well. It was also undisputed that after that quote unquote student boycott was made known, complainant made reference to that situation while students in his class were filling out end of the year evaluations. And the university, to me, reasonably found that that was inappropriate as well, trying to influence the outcome of what were supposed to be objective evaluations of his course. And even made, I guess, during that
Excuse me, Bob, I'm just wondering though, does that really carry on into this case? I mean, or is that something separate?
Certainly. No, I think it was just a part of just additional things where complainant just didn't seem to be exercising good judgment. The idea that you're referring to a situation that was could be disciplinary in nature, bringing this up during a course evaluation and then referencing how difficult the situation had been on his wife, it appeared clear that he was trying to influence the outcome of the evaluations by raising these points. While not sexual in nature, the university reasonably found that attempting to exert that kind of influence on people that were evaluating the quality of your course was simply inappropriate. And in this case, I think was also just raised concern when there's, a couple of people are always going to disagree or prefer one professor to another. But I think it was just the sheer volume of individuals involved in this boycott certainly got the respondents' attention in this case. I think, again, during the second so-called investigation, while it was again found that no formal violations of policy had occurred, that there were still disturbing incidents that were being raised by students, including making off-color remarks to certain female students. While complainant did dispute that those comments were made, again, I think was just the consistent nature of the comments was enough that it tied into his earlier, perhaps misjudgment in directing the scene with the female actor as well. I think in this particular case, again, clearly complainant disagreed that the seriousness of these allegations should have risen to an immediate discharge, and one can argue that point. I think, again, as respondent's attorney noted, there was an automatic triggering mechanism in this case in order to skip the 6-month period that's normally required to discharge an employee. And this panel is made up of other faculty members chosen at random. And in this particular case, there was unanimous 4-4 decision to uphold the immediate discharge. So clearly they believed that the conduct was serious enough to take that unusual step as well. Lastly, and as far as the ultimate decision for my report, the president of the university testified credibly at the fact-finding conference that her top priority in this case was ensuring the safety of students. And in this particular case, she had emphasized the lack of remorse on complainant's part, that confronted with the allegations, some of which appeared to be very credible, it was a question of deflecting blame onto others and either the unwillingness or inability to recognize that some of the decisions and his conduct and comments would have been inappropriate even if they were not illegal per se.
Thank you, Bob. Questions for the investigator, Commissioner Whitworth?
Let's see. No, but I did want to just make a comment to Bob that one of the last things you noted is that there is nothing in the record to suggest that complainant's discharge would not likely have occurred were it not for the filing of his commission complaint. Was a good comment to include in the report. So thank you for that.
And if I just to respond briefly again, I interpreted the commission filing as well as more of a defensive maneuver or an attempt to open up new front in this case. At the time that the commission complaint was filed, he was back on administrative suspension and he was aware that a fact-finding conference to ultimately decide his employment was right around the corner. So the fact that he filed the commission complaint and he was later discharged appeared to be an effort more to head that off as opposed to retaliation for him filing the complaint.
Interesting. Thanks, Bob.
Commissioner Helberg.
Just one thing, just to be clear, Bob, the allegation of, age discrimination, as in, encouraging him to retire. What did you find in regard to that?
Well, there wasn't any definitive letter that I saw that was entered into the record. My understanding was, and I'm sure it's like the same that goes on here with the state or with other entities, that there are certainly at times, in order to save money or for other reasons, encouraging certain individuals who are eligible to take early retirement to consider it. To me, was not any type of coercion forcing the complainant to consider retirement. It was simply laying out the options that he had as an individual that was approaching that option.
So it was just an option that was presented, not not a encouragement to do so.
Well, again, I think that in any case where somebody is being offered early retirement, there are usually nuggets of benefits that are offered in order to entice somebody to consider that option, whether it's some sort of severance pay or something else. But there was nothing introduced in this case that led me to believe that anybody was trying to intimidate him into retiring or face discharge.
All right, thank you very much.
Commissioner David, questions for the investigator?
Oh, thank you.
Okay. Thank you, Bob. So at this point, we've heard from the parties and the investigator, and we would be looking for a motion or motions. There are two proposed findings here. You could take them separately or together at your.
I would recommend that we take them both together and to accept the investigator's recommendation that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of age or sex, and there are no reasonable grounds to believe that the respondent discriminated against the complainant for engaging in WPA or act-related protected conduct, and that the charge should be dismissed in according with the act. Or in keeping with the act, sorry.
Is there a second?
I'll second.
So it's been moved to find no reasonable grounds on both sets of claims and seconded. Is there any discussion?
Yeah, I agree. I agree with the motion. I'm going to vote for it. It seems as though it's an accumulation over a long period of time of behavior. When you focus on specific incidents, whether that first touching was sexual harassment, okay, it was not, but it still creates an ongoing accumulation of behavior. I'm impressed with the faculty review. I think that's a safeguard. this is not a case of a student alleging that the university is creating a hostile sexual environment. This is a case of discharge because of behavior, and there's no substantial evidence that the behavior is based on improper age or sex discrimination just because he's a senior male.
Agreed.
Any further discussion? Hearing and seeing none. The motion is to find no reasonable grounds on both age and sex discrimination and retaliation. If you are in agreement, commissioners, please indicate yes by raising your hand and saying aye, or yes.
Aye.
Aye.
Okay, so the vote is 3-0, and the findings are all no reasonable grounds. So we still have 4 cases to go. This is, and I appreciate everybody who's waiting very patiently. Deb, do you want to call the next case? Do you want me to?
No, I can.
Okay,
Let me
great.
grab my agenda. Hang on. The case of, it's both employment and public accommodation, 19-0116, Candace Casey, the town of Rumford, Maine Soul, Rumford Career Center. Is there, let me find it. Is there anyone here for the complainant, Candace Casey?
I'm here. Can you hear me?
We can.
Yes.
Yep. So you have 10 minutes to make your presentation.
My first witness just walked out of the room. We'll get by without him. Good morning, commissioners, and thank you for your time. Let me begin by introducing you to the other half of the team, who I will turn the camera to if he decides to come back. The one who on site exiting the handicapped accessibility elevator triggered Town of Rumford Economic Development Director, George O'Keefe, to call the Rumford Police.
Hold on, Miss Casey. I'm going to ask you to pause. I paused your time. You cannot refer to witnesses. The only names that you can refer to are people who are parties, and you cannot present witness testimony at this hearing.
The witness was going to be an image of the dog.
Okay, unless you have
Not
run it
actually
by
the
us.
person, no, nobody's speaking.
Again, unless you have run it by me or our counsel first, so we can make sure it's something that has previously been provided to the investigator, and that then we can give it to the other party. You can't just show whatever you want as part of the hearing.
They would have access to the dog. And he was present. Development Director George O'Keefe to call the Rumford Police.
Again, Miss Casey, you can't use other people's names. We gave them pseudonyms in the report. You can't use their names.
I don't have any pseudonyms for anybody. I did not receive anything like that.
I mean, when we wrote the report, we didn't use that person's name, right? We referred to them in a different way.
Not that I'm aware of.
We did, because we don't put third parties' names in our reports.
So we refer to them as by their titles.
Or their employment function.
Right, so the investigator.
Director,
Right. So when you got the report, it didn't have that person's name in it, right?
I believe it did. And the person is named in my complaint would not be a third party.
The 3 respondents in this case are the Town of Rumford, Maine Soul, and the Rumford Career Center. Those names you can use. There are no other names that you can use.
In my complaint, I named the Economic Development Director of Rumford.
You mentioned him in your complaint. He's not a party, so he cannot be referred to by name here. In the report, he's referred to as director. So if you could refer to him as director, the commissioners will be able to follow along.
Called the Rumford Police Department, reported disturbance as a disabled person with her state licensed service dog had the gall to not only attend his job fair to apply for a job, but to use the handicapped access elevator to get there is confirmed by the career centers, and I have her name because she's also given testimony. I would begin today by asking you, am I allowed to show the dog?
No.
Okay. I would begin today by asking you to carefully review my complaint, both the online form and the narrative I supplied, along with the answers of the respondents and follow-up. Then with the documents before you, listen to the recorded interview by the investigator, in particular, the interview of, and I guess I've trained just of the Career Center. I believe you will be convinced beyond all doubt that the director acted in his capacity as the Town of Brockford's Economic Development Director, did not only discriminate against me due to my being a disabled person by interfering with my attempt to apply for employment, he singled me out as a disabled person to distract and cover for his misrepresentation of the status of the company coming, the facility they had yet to see, and the workforce of the Town of Rumford and surrounding area. And he weaponized the police of the town to accomplish his ends by filing a false report against a person unmistakably disabled. He has continued to make false claims and continues to tell people I caused a disruption that resulted in the company not coming, compounding the discrimination. When I read the most recent document sent to me concerning the investigator's report, I was shocked to see the investigator refer to me as an activist and protester. I believe this is a gross distortion and will refer you to the audio recording of his interview with the Career Center, from where I believe he got the idea to take her position, her positive description of me as an advocate, to turn it into something ugly in a time of activists and protesters burning, looting, and murdering around the country in the name of protest. The Career Center individual and I have worked together many times on bringing jobs to the area and working to keep jobs and in providing training to the many who find themselves in dead-end seasonal jobs and layoff after layoff, which you will hear in that recording. I believe he has taken her expressions of respect for me in her words as an advocate for the jobs and the disabled and turned them into something they totally are not. That I am an activist and a protester who would burn, loot, and murder, disrupt commerce, traffic, and more, including disrupt a job fair that we know has not been disrupted. To my knowledge, the only protest ever to take place in the area was a handful of BLM people in front of a Catholic church months after the investigators' interviews. And I certainly was not a
Ms. Casey, I'm sorry, I hate to interrupt you again, but a lot of the things that you are referring to are not in the record and were redacted from your submission, and you were instructed not to refer to them in your presentation.
I have not received a copy of anything redacted. I don't know what was redacted, if anything was redacted, because I have not received it.
My understanding is that it was emailed to you.
No, I got a copy of the agenda.
I have seen an email that went to you, Ms. Casey. I saw the email that went to you with the redacted version on it.
Then it probably was misnamed like the previous email that I did not receive, where my name was spelled incorrectly.
Okay, the fact that there were other protests some other time in some other place are not in the record or relevant to your case.
The investigator stated that I attended protests, and I'm stating no, I did not.
So then just say that.
I also found the characterization by the MHRC investigator that calling the police, refusing the application, denying the opportunity of interview of a disabled person because they used the handicapped access elevator to reach the job fair is anything but discrimination on the basis of disability, and in the case of filing a false police report, is simply ludicrous. I remind you, I, the obviously disabled person with a state licensed service dog, was the only person who was denied application, submission, and interview, and it was not by the company being applied to, but the Town of Rumford's Economic Development Director. It is up to the commission to make determination if what the director did in calling police and blocking submission of application and interview because I was a disabled lady, used the elevator intended for disabled people to reach the venue. Main Soul, the Career Center, even the interim town manager of Rumford said in his answers, and former selectman James Windover in his letter, that I caused no disturbance. No one did. And the director did discriminate against me on the grounds of my being a disabled person by calling the police, by blocking my application submission, and by blocking me being interviewed, because in his words, you used the elevator. Because as I said to him in response, because I am a disabled person with a service dog, and disabled people use the elevator. I don't think it would take any reasonable person any time at all, given the record, to determine that the Town of Rumford's Economic Development Director, in his official capacity, did not only discriminate against me on the basis of my being a disabled person, damaged my reputation and standing in the community by perpetuating the lie I caused the disruption of fair that resulted in Main Soul not coming to Rumford with jobs, and he filed a false police report that led to my being harassed by police at an event and in my being embarrassed. I trust the system and trust that you will find in my favor in my complaint against the Town of Rumford. As to the case in respect to the Town of Rumford, you will find that the interim town manager, the Rumford Board of Selectmen, the now town manager, and police failed to take action as required by law and required by Town of Rumford charter and ordinances, despite a formal complaint made to them, Rumford Police, and knowing that the original investigation from the complaint by the director confirmed that there was no disturbance caused by me or anyone else. The police department failed to charge the director with filing a police report. The interim town manager failed to hold the required hearing when a written complaint is received. The provision of Rumford government.
Ms. Casey, you are continuing to refer to things that are not in the record and that you have been instructed not to refer to.
All of that is in my complaint.
I do not believe that all of those things are in your complaint.
As a matter of training, that anyone taking instruction interview applications are instructed to know the company, learn about them before the interview in order to demonstrate to the interviewer you've taken interest in the company. Employers are more likely to hire people who have taken the time to take an interest in learning about the company before interviewed. As experience has shown, they will take more of an interest after hire. When I was shown an email written by the director sent out to his friends a few weeks before the job fair, is when I first heard of Main Soul. I don't recall a lot of details from the email other than the first person on the recipient list. And I'm skipping this part because I don't know if you're going to object to it or not. I noted Main Soul is the company he was holding the job for. Up to that moment, I had never heard of Main Soul. An internet search of the company turned up very little. I checked with people I know in the area they operate in and didn't learn much more. So I called, confirmed they were coming to Rumford to set up shop and whatever else I could to use at the interview to demonstrate my interest in the company. As you can see by the answers from Main Soul, that was shortly after the job fair and my call to the person on site, and then it's directed by the person, the CEO of the company, was so innocuous, so mundane, and so not an event. The CEO, in his answer to the complaint, didn't even remember the call or me. He stated his first knowledge of me was when Mr. O'Keefe gave him my application after the job fair was over. That to me removes director obviously far from honest or reasonable assertions I had caused the problem with the company coming with my call. Again, a call the CEO didn't even remember having. My call a few weeks before the job fair had nothing to do with Mr. O'Keefe's actions, discrimination of the basis.
Miss Casey, this is like the 5th time I've had to ask you not to refer to things that you're not supposed to refer to. You're not supposed to use people's names if they're not a party. I cannot keep
trying to not do it, but it's in my statement, so I'm doing my best to cut them out and switch it to director as much as possible, and I will continue to do so. A disabled person dared to attend his job fair and, worst of all, used the handicapped access elevator to do so. The other significant piece came from Maine Soul's answer to the complaint. They were unaware of any disturbance throughout the job fair. They were unaware, as confirmed by the Career Center, because there was no disturbance. Only the director filing a false report, having a disabled applicant harassed and refusing to allow the disabled applicant to deliver the application and have the interview at the job fair, the same as the able-bodied applicants. Again, the epitome of discrimination on the basis of disability. In my opinion, Maine Soul is just another victim of the town of Rumford's economic development director. But that will end up being your decision ultimately. I believe the written record speaks for itself. Each of you are more than capable of reading and understanding it. I will not beleaguer the narrative of what took place. I would like to highlight, however,
Ms. Casey, I'm sorry, actually, that's your time. And I've paused it every time I've interrupted you. So that's your 10 minutes.
I would just like to close with, I believe that both Maine Soul and the Career Center are not culpable in any of this. That the Career Center wasn't even a legitimate participant. Their name was used without their consent and in fact against their instructions.
Thank you. Commissioner Whitworth, any questions for Ms. Casey?
No questions, thank you.
Commissioner Helberg,
No questions.
Commissioner David?
No.
Thank you. Thank you, Ms. Casey. I'm going to put you on mute just as I do with every other party when they're done speaking. Commissioner, I'm sorry. Is there someone here for one or all of the respondents?
Stacy Carter,
And which party are you here for?
Town of Rumford.
Okay. Just so I know, is there anybody here for Maine Soul or the Rumford Career Center? Okay. Mr. Carter, you have 10 minutes.
Thank you. Let me just give you a little bit of background about myself. I'm the current town manager. I was not the town manager at the time of this incident. I was the sitting police chief. I want to thank the investigator for his thoroughness in this complaint. The town categorically denies the allegations of discrimination of Ms. Casey. We have handicap accessibility to the town office where this job fair was completed. We have accessible doors. We have a handicap elevator, which is for the purpose of allowing disabled people to get to the main and second floors of this building. I found no credible evidence where the director had made a statement that Ms. Casey was not able to apply because she used the elevator. It's customary for anybody to use the elevator to go to the auditorium. Some use the stairs, but most of the people do use the elevator. Ms. Casey is a frequent customer at the town office and frequently uses the elevator. It's not uncommon for any of the employees here to see her enter or exit the elevator. As the police chief at that time, I did receive a call from the director in reference to Miss Casey at the job fair. There was no comments whatsoever about the use of the elevator, but about the conversation that she was having, and that people shouldn't fill out applications due to identity theft. That's when the director had called me, and I sent an officer up there to see what was going on. I think the facts that the investigator was able to ascertain supports the no reasonable grounds to believe that Ms. Casey was discriminated against. And I ask that the commissioners uphold that that decision. That's all I have. Thank you.
Thank you. Commissioners, questions for Mr. Carter? Commissioner Whitworth?
No questions.
Commissioner Helberg?
No questions.
Commissioner David?
No.
Thank you.
Thank you.
Thank you, Mr. Carter. And now for the investigator, Mr. Gitchos.
Good afternoon, commissioners. I'm Milo Gitchos. I'm the investigator that was assigned to this case. I believe both parties have spoken to their positions. If you have any additional questions regarding any of my other findings, please feel free to ask.
Questions for the investigator, Commissioner Whitworth?
No questions.
Commissioner Helberg?
None.
Commissioner David?
Milo, is the communication with Maine Soul prior to the job fair, is that by email? Did you have that?
Oh, no, it was by phone.
Telephone, okay.
Yes, complainant had called various numbers at Maine Soul and eventually got to the president and spoke with him.
And did you speak to the president about that conversation?
I did.
Yeah, okay.
I did.
Thank you.
Any other questions for the investigator from commissioners? Seeing none. Thank you, Milo. Commissioners, at this time, we would typically have a motion or motions. There are two proposed findings here. So feel free to take them separately or together.
I'll move to take them together and find that there's no reasonable grounds to believe that Maine Soul discriminated against respondent, and no reasonable grounds to believe that the town of Rumford or the Career Center discriminated, and that the complaint should be dismissed.
Second.
So there's a motion to find no reasonable grounds on all claims, and it's been seconded. Commissioners, any discussion?
None.
Seeing none. If you agree that there should be a finding of no reasonable grounds on all claims, indicate so by saying yes or raising your hand.
Aye.
In favor of the motion?
Aye.
So the finding is 3-0. Finding of no reasonable grounds on all of the claims. The commission will send a letter to the parties. Thank you very much for your participation and patience, Mr. Carter. Okay, so moving along, next we have, oh, sorry, I keep usurping your position. Deb, that's you.
No, that's okay. So case, housing case H20-0233 ABC, Daniel Wall v. Maine Coon Management, Juan D. Arrieta, and New England Property Rentals. Is there anyone here for, just a minute, I got to get to the end here, for the complainant, Mr. Daniel Wall.
Mr. Wall is here by phone, I believe. Mr. Wall, can you hear us? His phone is here. Mr. Wall?
Hello?
Aha, is this Daniel Wall?
Yes, it is.
Okay, well, you are up. The commissioners have
I'm up
called
to bat, huh?
What's that?
I'm up to bat, huh?
You're up to bat, that's right. You have 10 minutes to present your case. And again, please recall, you can't present anything that was not previously provided by you or the other party to the investigator.
Okay, I will summarize my what do you call it?
Your case?
I'll summarize my opening basically. I had called the defendant. Can I say that?
You can. So you can refer
Okay.
to Maine Coon Management or Juan Arrieta or New England Property Rentals. Those three names. But other than that, no other names.
Okay. So all three of them worked together and all three of them conspired to discriminate against me by making false statements and supposed emails that they sent me. I am a computer guru. There is no way that they ever sent a email to me that I would not receive, because I can go into files and find them if I need to, because I used to work for the NSA and they're not there because I have favors that I ask.
Mr. Wall,
Also-
Mr. Wall, I'm
Yes.
sorry to interrupt you, but that bit about the NSA, that's not in the record here. So I'm going to ask you to.
Sorry.
Yep.
Okay, now, with my experience, the defendants usually do this to cover up information, and thusly I had to make a case because of their inadequacies in handling a disability case with a disabled person as myself. I would like to go on record that I don't think I've been treated fairly in this process by the defendants, and I will close at that.
Okay. That is very succinct. So you will have additional time later on, but first I'm going to see if the commissioners have questions for you. So hold on
Good.
just 1 second. I do keep track of how much time people use, so I'm going to write it down so I don't forget. Okay, so questions for Mr. Wall, Commissioner Whitworth,
No questions.
Commissioner Helberg,
None, thank you.
Commissioner David.
Mr. Wall, do you claim that you had all the correct documentation in a timely manner? That seems to be the thrust
Yes,
of
I
the
did,
denial.
including my birth certificate and my Social Security payment page where they sent out, how much I'm getting and when I'm during the month.
And they say
They had
and-
all the
and-
information.
And they say you did not get it in a timely manner, correct?
Correct.
Okay,
That's what they say.
I got it. Thank you. That's it.
Okay, so that's, I think, is all the questions for you for now. Mr. Wall, hang on, and we'll get back to you to present, if you want to, with additional time after we hear from the respondents, if they're here. So hang on. So then the next question is if there's anyone's here for any of the respondents. Is anyone here for Maine Coon Management, Juan Arrieta, or New England Property Rentals? There's a number that ends in 603 something. Is whose phone is that?
677.
Yeah, 603 something, 677. Is that someone on
Oh,
behalf?
1677, that's me.
Mr. Wall, that's you? Okay,
Yeah,
okay.
no
So
show.
I haven't heard from anyone on behalf, there's nobody here. Well, there's no other squares unidentified here. So presumably there is no one here on behalf of respondents. Mr. Wall, do you have anything additional to present? You have, if you want to use them, you have about 8 minutes left.
So what was that question again?
Do you have anything else that you want to present? You have about 8 minutes left if you want to use them. You don't have to.
I think the record says everything, including the respondents not being here because they know that they did something wrong. End statement.
Again, admirable succinctness. Thank you. Commissioners, any other questions for Mr. Wall before we move on to hearing from the investigator?
None on my part.
Okay, I see shaking heads. Nope, all set for questions. All right, Mr. Wall, I'm going to mute you and then we will go to hearing from the investigator.
Alice. Commissioners, yep, I'm Alice Neal. I had this case and this is my investigation. So I haven't heard anything from Mr. Wall today that would change my recommendation. During the course of my investigation, I got information both from complainants and respondent. And what the record reflected to me is that Mr. Wall did receive communication from respondents. He was sent this respondent's answer and he did write back and say it's false, but he didn't provide me with any particular evidence that would show that he didn't receive, well, if he didn't receive the messages or he didn't provide information when I'd asked him to provide some information about the case in response to a request for information. He never responded. He didn't appear at the Issues and Resolutions Conference. And what I saw is that the record showed that he reached out to try and rent a place, that the respondents did try to work with him. They tried to follow up with him. From their perspective, he didn't respond. And this was happening over a fairly short period of time from the middle of March through early April. And so they reached out at one point and said, do you have additional information? Are you still interested in the unit? And Mr. Wall wrote back and said yes, but they still didn't have the information to complete his application to consider whether or not he would be eligible. The information that he provided about his income may have disclosed in terms of if you're looking at it, think that SSI income would be related to disability or that it's disability based. However, there's nothing in the record that I saw that put respondents on notice that said Mr. Wall is disabled. And so I don't believe that any of their decisions or actions in terms of not running to him are based on his disability. What seems to have happened is that without the information to fully assess his application, there was another prospective tenant who was disabled who applied at the same time. And they had all of the information that was complete and there in the record for respondents to consider. And so they went ahead and accepted the applicant who had provided them with all of the complete information for their application, who also happened to be disabled. So based on that information, I found that there was nothing that, even if respondents knew about Mr. Wall's disability, that their actions weren't based on discrimination based on his disability. They clearly rented to someone who was disabled. The building was accessible, and my own interactions with Mr. Wall and not responding to my investigation, responding to information, showed that I didn't think that he didn't give me anything that would show otherwise in terms of the case. And so I still believe that there are no reasonable grounds to think that discrimination occurred based on his disability in this case. And I'm happy to take any questions.
Thank you. Thank you, Alice. Commissioner.
Do I get that question?
Nope, Mr. Wall, nope. We are not hearing from you at this point. This is only at this point between the commissioners and the investigator. Commissioners, any questions for Ms. Neal? Commissioner Whitworth?
No questions. Thank you, Alice.
Commissioner Helberg?
None, thank you.
Commissioner David?
No, thank you, Alice.
Yes.
Okay, so we've heard from Mr. Wall and we have heard from the investigator. So at this point, we would be looking for a motion or motions. I
I would
believe
move-
there's one proposed finding, sorry.
Yeah, there's one.
Yep.
I would propose to uphold the recommendation of the investigator.
Second.
So I don't get no
No,
rebuttal.
Mr. Wall, we are not hearing from you at this point. This is just the commissioners. Your time to present is over. You can listen.
There are no reasonable grounds to believe that the respondent discriminated against the complainant based on his disability, national origin, and/or ancestry when it refused to rent to him, and the complaint should be dismissed in accordance with the act.
Second.
So the motion has been made and seconded to find no reasonable grounds to believe unlawful discrimination occurred. Is there any discussion between commissioners?
None on my part.
No.
No.
Okay, so then the motion is to find no reasonable grounds to believe a discrimination occurred. If you vote yes, you are voting in favor of that. Commissioners, if you could please indicate your vote by raising your hand and saying yes.
Yes.
Or no, as the
Yes.
case- Yes, so 3 votes in favor of the no reasonable grounds, finding no votes opposing it. So the vote is no reasonable grounds. The commission will send a letter to the parties. We have 2 cases left. Shall we forge on?
I apologize. Could we take another 5-minute break?
Mr. Wall, I appreciate you being patient, but we have finished hearing your case.
You haven't heard from me yet
We
about
did.
questioning. I
No.
want to question the investigator.
That is not how the process works. I thank you. If you are not cooperative, I will.
Well,
be
this
forced
is
to
an illegal process against the handicapped, and the Bill Barr will.
Okay. Did you ask for a brief break, Ted?
Yes, I did, like 5 minutes.
Okay, thank you. I don't think I've ever had to eject anyone before. Man, I'm going back on vacation.
You're going back on vacation just for that?
No, takes a little more than that.
Right.
That's just another day in the office, Ed. Except that I'm not in the office.
Right.
Thank you, Amy.
Yeah. Let's see.
Also want to thank you for being proficient in ASL. I didn't know that. That was impressive.
I have no idea if I'm not sure that the complainant thought it was impressive, but
Well, I thought you did pretty well, so.
I appreciate that. Once upon a time, I was proficient. I am not sure that I am anymore.
Well, when I was in like the 6th grade, the school said we couldn't talk anymore. And we all, started doing all the sign language. And that's the only thing I know is just like the ABCs of it. And that was it.
Yep.
But thank you.
Yeah. So I believe we have both parties for the next case. And then I know I saw counsel for respondent in the last case. Okay. So everyone who's hanging on is a champ. Let's see. This is the last case for the day of Jane.
What's the number? I'm sorry.
I think the next one will be H2O0238.
Yeah, Reed and versus Cloran.
Lauren, yep.
Okay.
All right. Deb, do you want to call the next
Sure.
one?
So the next case is H2O-0238, Alana Reed v. John Cloran. Since this is a reasonable grounds case, is there anybody here for John Cloran?
And I believe Mr. Cloran is here.
Yeah, he was here earlier.
Yeah, he's still on the line. He may have thought that when we said a 5-minute break, we actually meant 5 minutes, but Mr. Cloran, can you hear us? And if you can hear us, can you unmute yourself? I'm sending him a message asking him to unmute and go on video, but he may have stepped away for a second. Oh, wait. Oh, there he is. Now he's up there. That's confusing. Okay. Oh, okay. We've got video. Aha, excellent. Okay. Mr. Cloran, you are up. You have 10 minutes.
All right, so as far as I can tell, the case is because I asked for permission to speak to a therapist for an individual who was trying to rent one of my apartments. Briefly, the complainant came in, wanted to rent my apartment. I wanted to rent it to her. She had an assistance animal. She gave me a letter for that animal, and on the letter, it was dated over a year old. Through my website searches,
I'm sorry, I'm having trouble. I'm having trouble following this.
Letters
Mr. Cloran,
animals.
Mr. Cloran, just so you know, it seems like
Yes.
You may, I'm not sure if it's
Yes,
that connection. It's sort of cutting in and out and warped a little bit. I'm not sure if there's anything you can do, but just so you know, it's a little difficult to hear you.
I will try to repeat if you miss anything. Can you hear me now?
Yes. Yep.
All right. A lady, the complainant came in to rent my apartment. She had an assistance animal. She gave me documentation for the animal. The documentation was over a year old. I set the paper aside and we finished signing the lease. It took over 2 hours to sign the lease because I had a checklist for the Maine, for all the forms that Maine required. I wanted to be in compliance with the law. I tried my best to be in compliance with the law. At the end of the lease, I took the paper that I thought was out of date and I asked, and on that letter, it said, it directed me to ask for permission to speak to the therapist. I wanted to do that so I could have the therapist update the letter so everything would be legal. The complainant then, within 48 hours, tried to back out of the lease several times before I had to direct her, if she wanted to do it, to back out of the lease, she had to write a legal form saying that she wanted to back out of the lease. So it would be done legally. Apparently, by asking for permission, by following the letter's directions, I was breaking the law. This was unintentional on my part. I wanted her for a tenant. I noted during the previous findings that I did multiple research websites and found multiple websites that said all letters, ESA letters, expire after 1 year. That was on a half a dozen sites. This was all in previously documented findings. I don't know what else to tell you other than I wanted her for my tenant. I wanted everything to be absolutely legal, which is why it took 2 hours to sign a Maine state lease. We went through every single page, documented and dated it, so everything would be legal. The directions on the letter itself said, if you have questions, ask for permission to call me. So I asked for permission. That was it. I didn't call the therapist. I wasn't a nuisance. I asked to call the therapist. I don't know what else to tell you. I'm sorry, but that's the crux of it. If I broke the law, it was definitely unintentional. I did it unwillingly, and it was without any malice whatsoever. In the middle of the winter, I wanted a tenant. Trust me on that one. Nobody wants an empty building in the middle of the winter. So that's it. I'm sorry if it wasn't presented properly or as professionally as some of the other participants today, but the crux of it is I was trying to comply with the law. The paperwork, the legal paperwork that you gave me to document the animal said, ask for permission to call. I asked for permission. I don't know what else to tell you.
Thank you, Mr. Cloran.
You're welcome.
You'll have some time left after we hear from Ms. Reed. But first, I'm going to ask the commissioners if they have questions for you. Commissioner Whitworth?
No. No.
Commissioner Helberg?
No questions.
Commissioner David?
Did you withhold the lease from her because you hadn't talked to the providers? Did you withhold the apartment and the keys from her?
I had the keys and the signed paperwork documented, copied, and ready to give to her once everything was legal. And by that, I mean, once I received the letter saying that the letter was real and that she really did have a documentation for the animal, it was going to be passed over. The complainant knew this.
You had those letters from the providers, from the health providers.
I had a letter from the provider, and that letter said, if you have any questions, ask for permission to call.
I understand. You had those letters and
I
you
did.
withheld the apartment from her because you wanted to talk to them. Right?
It was in effect, yes.
Thank you.
It was a simple verification I was asking for.
Thank you. So at this point, we would turn to Ms. Reed.
Thank you. I would like to thank the commission for hearing my case and also for working through lunch. I understand how that can be sort of hard sometimes. I just want to first call attention to the top of page 3. There is a small typo there in the investigator's report. It states that the complainant has no reasonable or legal grounds for his inquiry. It should say respondent had no reasonable or legal basis for his inquiry, unless it should say her, which would refer to me. So
you're correct.
Okay. All right. So this is my analysis from Mr. Cloran's rebuttal to the investigator's finding. Mr. Cloran explains in his rebuttal in number 2 that the investigator failed to mention that I omitted that I had a pet on the rental application. This was discussed during the investigation. My omission on the application was not a true failure of disclosure. Mr. Cloran's application asks about pets, but not service or assistance animals. The argument should be dismissed outright as my animal is not a pet, but an assistance animal. Mr. Cloran claims that it is within his right as a landlord to verify the authenticity of letters provided by lessors for emotional support animals. While he may claim that this action was necessary, it is an invasion of privacy. He claims that the issue of fraud is rampant with ESA letters, and Mr. Cloran states verbatim the Maine Criminal Code Title 17, Section 1314-A, misrepresentation as service animal or assistance animal, and has tried to state that my letters were fraudulent. The investigator has ruled that my letters are not fraudulent and that I have not misrepresented my animal as not an assistance animal, or as an assistance animal. However, Mr. Cloran claims that he cannot possibly be able to know other laws surrounding assistance animals, C3A2. Despite this, as a landlord, Mr. Cloran must know many laws about how to maintain a proper abode, including what is expected to ensure the health and safety of all residents that lease for him. He has gone out of his way to know the particularities of misrepresenting a service animal, but he cannot know what properly constitute a letter from an assistance animal. This leads one to believe that Mr. Cloran picks and chooses what he wants from Maine law, including the Maine Criminal Code. Additionally, the Maine Human Rights Commission has already dealt with the claim that ESA letters from internet providers are fraudulent. See Sweeney versus Northern New England Conference of Seventh-day Adventists and Frodmeyer versus Desjardins. Mr. Cloran states that it is within his right as a landlord to verify the authenticity of a letter regarding an assistance animal. However, because the misrepresentation of a service animal is considered a criminal violation and not a civil one, it seems that Mr. Cloran perhaps should have spoken to a law enforcement officer or the Maine Human Rights Commission for supposed misrepresentation filing a criminal complaint. It is not under the rights or duties of a landlord to decide what a fraudulent document is or is not. In Part B, Mr. Cloran states that a general Google search shows that one must renew letters for ESAs yearly. Despite this assertion, the statutes of the Maine Human Rights Code defines an assistance animal under 5 MRS section 4553(1)H as an animal that has been determined necessary to mitigate the effects of a physical or mental disability by a physician, psychologist, physician's assistant, nurse practitioner, or licensed clinical social worker. The word determine states that this may be done on a one-time basis, that the medical provider does not have to continuously determine if an animal is necessary again and again on a yearly basis. A strict reading of the law allows for the determination to be once by a medical provider. This is also supported by previous decisions by the Maine Human Rights Commission, see number 1115-0200, HUD number 101-L50296-8. While Google and the internet allows for many sources to be found regarding any given subject matter, this does not replace the actual law decided and voted on by the Maine legislature. Mr. Cloran claims in C1 that my letters from my medical providers had led him to commit a human rights violation. Instead of admitting culpability for his actions, he again denies any wrongdoing in the matter. I remind the commission that he did not allow me access to the apartment without first speaking to my medical professionals. He asked my land company for my medical diagnosis and asked for access to my medical records as seen in the investigator's report. Again, Mr. Cloran fails to take responsibility for his behavior. In C2, Mr. Cloran again states that he cannot find any alternative solution but to contact the writers of ESA letters. The investigator in this case has noted that Mr. Cloran could have Googled the medical providers that wrote my letters and looked for their license numbers in the Maine database on the Maine state website. It is not only that Mr. Cloran violated my rights by demanding to speak to my medical providers to ensure authenticity of the letters, but also because he withheld the lease, asked for my medical diagnosis from my current land company, and asked for access to my medical records on the phone when he spoke to me. Taken in its totality, Mr. Cloran's extensive actions to keep me and my assistance animal out of the apartment constitutes discrimination. I am finished with my rebuttal.
Sorry, I said thank you. And commissioners, questions for Ms. Reed, Commissioner Whitworth?
No questions, thanks.
Commissioner Hellberg?
None, thank you.
Commissioner David?
No.
Okay. Ms. Reed, you'll have about 2 minutes left, 2 minutes and a few seconds. But first, we're going to go back to Mr. Cloran, who has a few minutes left. Mr. Cloran, you have about 3.5 minutes left. If you would like to use them, you don't have to.
Yes, I would.
Okay.
It's been brought up that the letter was not fraudulent. Then I should have believed the letter, which I did when I followed directions on the letter, which specifically said, ask for permission to speak to the therapist. I in no way wanted medical information from anyone. I'm an XRN. I was protecting patients' medical records all my life. I would never ask for that. Nobody would. Nobody in their right mind would ask for medical information on anybody. I wanted an update on the letter, period. End of story on that. On the Google search, which led me to believe that there was a 1-year expiration on letters. If you Google search ESA letters, on the first page, 6 websites come up that all say the same thing. 1-year expiration for ESA letters. When I Googled the main site, main law, I didn't see any of that. License numbers on a letter does not necessarily mean that that letter is a true document. Copy and paste can do that in 2 minutes. I can look up a license number and slap that onto a piece of paper and put anybody's name on it, and that would be a fraudulent letter. I wanted an update on the letter to make it legal for the record. I was a policeman, a military policeman. I don't do things, legal things haphazardly. I try my best to do it by the law, which is why it took over 2 hours to sign a Maine state lease. There was no intent on my part to discriminate against this complainant. I wanted her for a tenant. I also wanted everything to be legal, which is why I asked for an update on the ESA letter. Thank you.
Thank you. Any questions for Mr. Cloran, Commissioner Whitworth? No.
Sorry, no questions.
Commissioner Hellberg?
Just wonder, I mean, again, it's not the intent, but the effect. And so you did not intend to infringe upon the rights and then discriminate. But is it true that you just denied because of this?
It was a simple process. If somebody gives me documentation when they sign a lease and they say they make X number of dollars for income, I bear income. It's reasonable. Date from 6 websites that have documented that this is definitely out of date. And I set the paper aside and ask for.
I'm sorry, you're really breaking up on us right now. I can't really understand you.
I don't know how that can be willful discrimination.
Sorry.
Okay.
Just so you know, it's cutting out and we can't really hear you.
I asked for documentation because the letter asked me to do just that. I wanted the updated letter to be in compliance with the law.
Commissioner Hellberg, any additional questions for Mr. Cloran?
No, thank you.
Commissioner David, questions for Mr. Cloran?
It was after you told her you wanted an update that you went to her former landlord or then current landlord, right?
Yeah, yes. I've been a landlord for about 30 years. And it has been my experience that although most tenants give accurate information, some of them do not. I wanted to verify that there was actually no problem with this tenant.
And so you did that after you'd already signed a lease with her?
Correct. And the reason for that, again, a long time ago, but a lady came over to rent one of my apartments. She had everything in order.
Is this in the record? I'm sorry.
Yes. Yes, I'm sorry. So a long time ago, a lady came over and wanted to rent an apartment from me. During the process, all of her references checked out. And during the process of me talking to her, she had a low-cut dress on, and she kept flashing me during the entire process. Although her references checked out, I went to verify her references again, this time in person. And when I did, I found out it pretended to be. She hadn't paid rent. She had skipped out on the last rental unit. That's why I went to check to verify what was said from this management company.
Thank you.
I'm good.
Okay, thank you. I think I just asked Commissioner David. I think you said you were all set. Is that accurate? Okay, thank you. Thank you, Mr. Cloran. Ms. Reed, you have, I wrote it down somewhere, but somehow I didn't. I think you have about a little over 2 minutes.
Yes, that's.
Oops. Sorry, I muted you by mistake. Sorry. Okay, go ahead.
Sorry, I just turned it back on. Oh,
Okay.
Wait.
No, we're good. We're good.
Okay. I'm sorry. Okay, so I also provided a letter from my doctor that also very clearly states at the end, please feel free to contact our office with any questions. And Mr. Cloran did not take issue with that letter, but he very clearly wanted to speak to my therapist. And it was because of these very scary and encounters with Mr. Cloran after we signed the lease that I felt that it was just too terrifying to live in the same quarters as him, and I canceled my lease. And I do not think that him going to my land company was appropriate. I did not know until I picked up the letter from my current land company that he had asked them for my medical diagnosis. So I don't know. It's kind of scary situation to be in for a tenant. So
A question for Barbara. Any HIPAA violations here?
I don't mean to say that it doesn't matter, but it doesn't matter for our purposes.
Okay.
We don't enforce HIPAA, so.
Right.
Understand why you're asking, but.
Before we move on to commissioners' discussion, let me just see if there's any additional questions for Ms. Reed. Commissioner Whitworth?
No questions.
Commissioner Helberg?
No, thank you.
Commissioner David? Okay, thank you, Ms. Reed. At this time, we'll go to the investigator, Ms. O'Reilly.
Good afternoon, commissioners. Once again, Jane O'Reilly, and I was the investigator on this case. I don't really have anything else to add. I'll just re-emphasize what's in my report, that though Mr. Cloran was able to find internet sources that cited a 1-year requirement, there is no requirement that letters be updated every year in Maine state law. So I'm happy to answer any questions.
Questions?
Yeah, I just have this. I mean, so let's say that I, or he Googles and we find something that says one thing and we believe it, we believe that and rely on it. I guess that does not circumvent, what the requirements are. I mean, I'm just wondering if, based upon what he knew, was that legitimate or not?
I'll go ahead and answer that, and then if Barbara wants to jump in, unfortunately, there's no intent element. So a mistaken belief in what his legal obligations were is not a defense to a violation.
Commissioner Whitworth, any questions for the investigator?
No, I don't have any. Thanks, Jane.
Commissioner Helberg?
No, so basically ignorance of the law is no excuse, right? All right, thank you.
Mr. David?
Jane, did you talk to that property manager, the current landlord?
The one that Mr. Cloran went and visited?
Yes.
I did not speak with her. However, there is a statement provided in part of complainant submissions about her account of that event.
Okay, so she submits a statement that contains those indications that she was distressed by his behavior and called the complainant.
Yes, those characterizations are hers and they're contained within that written statement.
I do have one question, and it may be one for Barbara. I'm just struck by the definition on page 2 of an assistance animal. It says that the animal has been determined, and then lists the people that can make the determination, or has been trained to perform a task. Is it really in the alternative? So that the second prong is sufficient if you can show the training to perform a task that's related to the disability?
Yes, that's the standard for a service animal. So that is a service animal would be an assistance animal by virtue of their training to perform a disability related task.
So you don't need the documentation if you met that second prong.
Not if you can demonstrate via training that
Right.
the animal, whatever it is, because it can be anything in an apartment, can perform a disability related task.
Thank you.
Okay, so we've heard from the parties and the investigator. At this point, we would look for a motion. There is one proposed finding here.
I'll move that there are reasonable grounds to believe that the respondent discriminated on the basis of disability, and conciliation should be attempted.
Is there a second?
Second.
So there's a motion to find reasonable grounds and a second. All those in favor, raise your hand and say aye.
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 2, 3. So the finding is that there are reasonable grounds to believe unlawful discrimination occurred. The commission will be sending a letter towards the end of this week to both complainant and respondent to recount the finding and to tell you the next steps in the process. And we appreciate your patience with today's hearing. Thank you. Okay, the last case. I don't know if complainant is here, but I know that there is someone here for respondent. Okay, Deb, I have once again usurped you.
So PA 19-0139, Linda Hadsell v. Ming Lee Chinese Restaurant. This is a reasonable grounds case. So is anybody here for Ming Lee Chinese Restaurant?
Good afternoon, Commissioners. I'm Mariah Gleaton here, and I have May, the co-owner of Ming Lee.
Okay, go for it. You have 10 minutes.
Thank you. Good afternoon. I appreciate your patience. I know it's been a long day because I've been on the phone or on the video for the whole day, and I had a break and was able to eat, but I know you guys haven't. So we're here today to determine whether reasonable grounds exist to believe that Ming Lee engaged in discrimination against Ms. Hadsell on February 1st of 2019. Before the commission, you have two very different versions of events as to what occurred on February 1st, 2019. There's information from Ms. Hadsell and there's information from Tanya Buzzard, the host, which is not the manager.
Miss Gleason, you can't use names.
Oh, I'm sorry. Yeah. From TV, the hostess. I think she's referred to as manager within the findings, but I believe that was the only place where she's referred to as manager, and everything else indicates that she was the hostess. So I think it's really important when considering the facts and putting them together to determine whether there's at least an even chance of the plaintiff prevailing in an action, which would be the reasonable ground standard, is to look at the facts that aren't contested and to see if those fit the narrative of the accusations of Ms. Hadsell. And I think if we look at those closely, the conclusion would be that they don't. I want to specifically look at the facts that we know are not contested. That would be that the hostess has worked at Ming Lee's for 8 years, and she's been in the restaurant hospitality business for 26 years. That's a lot of experience. That's a lot of experience specifically at Ming Lee's restaurant and a lot of experience over many years. The other information that's uncontested is that Ming Lee allows service animals in its restaurant. And we know that because 2 patrons were willing to come forward and say that that's exactly what they've experienced when they've attended Ming Lee's restaurant. They've been allowed entry and they bring their service animals. The other thing that's uncontested is that no information was provided or exchanged between Ms. Hadsell and Ming Lee Restaurant regarding what task the dog was trained to perform. There was no information provided by Ms. Hadsell about that. So there are 2 assertions that Ms. Hadsell made that don't really fit into those uncontested facts. The first is she claims that the hostess said, "We don't allow service animals because we don't want fleas in the restaurant." It doesn't make sense for the experienced hostess to have made that statement because it's not the policy of Ming Lee's restaurant to not allow service animals. Other patrons have brought service animals in. The other piece that I think we have to question is Ms. Hadsell reported that she didn't have an opportunity to explain what task her dog was able to perform. However, she did say that she was able to make an offer of her own to provide information regarding her service animal in the form of a license from her, I believe it was her town. So she was able to offer some information as a part of the exchange, but she wasn't able to offer that critical piece of information. Now, the facts really differ here because the hostess says she requested that information to be provided and Ms. Hadsell didn't provide it. And Ms. Hadsell says she just never had the opportunity to provide it. But she was able to provide other information that she thought was relevant during the exchange, according to her own statements during the investigation. So those 2 things, I think the commission has to consider if those 2 facts, those 2 allegations by Ms. Hadsell don't fit into the facts that are uncontested, is the rest of what she says believable? And is it believable that she'd be able to, and I don't want to repeat the exact language that the commission has to consider as far as the standard. Is there at least an even chance of the plaintiff prevailing in an action when some of what she says is just so contrary to the facts that are uncontested? And I would put to you, and I'm sorry about that, May's phone just went off.
Sorry.
I would put to you no, and that standard, the reasonable ground standard is not met in this case. If we take the respondent's version of events and the communication that took place, the hostess asked her if it was a service animal. The complainant did not respond. The hostess told Ms. Hadsell that if the dog was not a service animal, she had to leave but could order takeout. The complainant then left. She had an opportunity to communicate what she wanted. She decided to leave the restaurant. She wasn't escorted out. And under that factual scenario, no such discrimination occurred. All right, thank you for your time.
Thank you. Questions for Ms. Gleaton? I probably mispronounced that as well, and I'm sorry.
You're good. Mariah, that's fine.
Okay. Commissioner Whitworth.
No questions, thank you.
Commissioner Helberg.
What were the specific questions or comments that were made by not the manager, but the hostess to the complainant?
So she approaches Ms. Hadsell. She sees an unleashed dog on her lap. She asked, is the dog a service animal? Ms. Hadsell did not respond. She stated, if the dog is not a service dog, she had to leave, but could order takeout, and then the complainant left.
Did she ask at all of what kind of service the animal provided for her?
Yes, so I'm sorry, I missed that. And I'm sorry, just reading through the facts, the statement again. She did ask, what task was the dog able to perform? What task the dog performed? I'm sorry.
Mm-hmm.
So she did make that inquiry and no information was provided. And then it was then the hostess went on to say, if the dog is not a service dog, she had to leave but could order takeout. So that question was asked.
All right, thank you.
Commissioner David.
Did she ask for medical papers, meaning documentation of the animal status?
No.
So her version is that complainant made that up.
Correct. Or
Okay.
right. She
All right.
never she never made any requests.
Right,
And she never offered any type of paperwork.
I'm just trying to see where the credibility issues arise.
Correct.
It's also her position, respondent's position, that there was no vest, no other outward signs that it was a service animal, and that she made that up.
Correct. Well, yes, essentially. There are other dogs that frequent the establishment that are service animals. This dog did not appear to be a service animal. There were no outward indicators that the dog was a service animal. When a conversation was engaged in with Ms. Hadsdale to inquire about the dog's status, that information wasn't provided. She was given an opportunity to order takeout, or she could leave if the dog wasn't.
I understand. So if she had answered the question about what the dog was trained to do, and if she'd said detect low blood pressure, there wouldn't have been any problem, and she wouldn't have asked for, continued to ask for medical papers or documentation. That's a little hard to believe.
That's correct. That's correct, though. I mean, that's
All right.
what you have to take if someone's saying it's a service dog and they explain the task it's performed, we have to take that at face value. There's no additional inquiry that the restaurant or the hostess could ask for.
Okay.
Let me ask this, though. That's a hypothetical in my mind. So if she had asked for it and there was no vest or anything else, she may have responded differently. Is that correct?
I have no idea. Exactly. I mean, this is how she should respond in order to, follow up, but that conversation didn't happen. So I would just be speculating. I can tell you what the best response would be.
I don't want you to speculate. I'm sorry.
My response to Mr. David was speculation, in that she has a lot of experience as a hostess, but she would respond. I can't guarantee how she would respond.
Okay.
Thank you.
At this point, we're gonna turn and see if, there's nobody here. I would turn and ask if there's someone here for complainant, but I control who's here and I see who's here, and there's no one here for complainant. So is there anything else that you would like to add on behalf of respondent?
No, thank you.
Okay, thank you. Commissioners, any other questions for respondent before we hear from the investigator?
None on my part.
Okay.
I don't have any.
All right, thank you. Mr. Gitchos.
Good afternoon, commissioners. Gitchos, I was the investigator assigned to the case. The case did present a Rashomon-like scenario where one thing is reported, but multiple opinions or interpretations of what occurred were varied and vast. At the end of my investigation and after reviewing all of the information, what I thought was most logical was clearly communication occurred between the hostess and complainant clearly felt that their dog was not welcome. And that was the foundation for my decision. If you have any questions, please just feel free to ask.
I have a question.
Yes.
Is it safe to say that your decision was based upon speculation? Or is it safe to say that you have actual evidence that discrimination occurred here?
The evidence, the factual evidence that I have available to me is this: that the complainant entered the restaurant with an animal, there was a conversation or some communication regarding the animal. And then the complainant left the restaurant. Those are the facts that I have. Now,
Do we know specifically what was asked and what was not asked? And do you have any evidence on that?
No. Hostess gives one version of events and complainant gives a completely alternative version of events.
So did you base your recommendation on the credibility of the people or what?
On the facts that there was a communication. That communication would have had to have begun with something regarding the animal. In the testimony, one piece that is clear is both sides do agree that respondent, the hostess, spoke first, and that it would be an inquiry into the nature of the animal. After that, there was some discussion as to the legitimacy of the animal, and then complainant felt compelled to leave.
Do we know specifically what the hostess said to the complainant?
We have what the hostess has stated, and then complainant stated that essentially if it was not a service animal, she had to leave.
And how have you verified that?
My interview with complainant.
So you rely completely on the complainant?
No, I rely on what would have actually occurred versus what said, in that she had to go into the restaurant and there would have been discussion between them. That is agreed on. And then something occurred regarding discussion of the animal. And then the complainant felt compelled to leave.
All right, thank you.
Commissioner David, any questions for the investigator?
Can we take anything from the failure of the complainant to appear at this hearing? This is a chance for her to present her case and for us to look at her, is it not? I guess that's a question for Barbara, maybe.
Do you have a question for Milo at the moment?
Well, Milo, what's your answer to that question? Can we take anything from the failure of the complainant to appear at this hearing? Do you take anything from it?
No, I do not.
So we can make this determination. Okay. No, can I ask that question to Barbara?
You can, and you certainly can consider it if it's something that influences your decision. It doesn't necessarily mean one thing or the other, but it's something that's happened in this case.
Well, I understand. This is a credibility case, and Milo has set it up that way, that there's a difference, and the question is the reasonable likelihood of success standard. So I think it's relevant.
The question, the standard is whether there's at least an even chance.
At least an even chance.
That evidence would be developed that would lead to success in a civil case. So
exactly.
Any additional questions for Milo from the commissioners? Seeing
none on my part.
Okay, thank you, Milo. So at this point, we would expect, or we would be looking for a motion.
I'll make a motion. Make a motion that we overturn the recommendation of the investigator to say that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability by denying her the use of a service animal, that the claim should be the claim should be dismissed in accordance with the act.
Is there a second?
I'll second.
So there's a motion to find no reasonable grounds and a second. Is there any discussion? Oh, you're muted, Ted.
Sorry. Yeah, I mean, this is a difficult case. I mean, obviously it could go either way, but I'm concerned about the complainant not being here. I'm also concerned that, you know, it is a credibility case on what was said and what wasn't, and that the respondent was here and presented a valid case, I think, for no reasonable grounds. So that's why I made the motion.
Yes, I agree, Ted. When I read this case, I was fully prepared to say that there was at least an even chance that evidence could be developed to support the reasonable grounds finding. But I take it's not dispositive that she's not here, but it is certainly significant to me because I don't have that statement that, yes, this is how the dog is trained. It had a vest, it had a leash, and given that, if that had been on the table, then it would have been a toss-up, which would have been reasonable grounds to believe that it's possible she could have been successful in litigation. So it's extremely important to me, and that's why I'm going to vote for the motion to find no reasonable grounds.
Any further discussion?
No.
The motion is to find no reasonable grounds to believe discrimination occurred. If you vote yes, you are agreeing to a finding of no reasonable grounds. All those in favor, raise your hand and say aye.
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 The finding is 3-0. The finding is no reasonable grounds to believe unlawful discrimination occurred. And as I've said previously, the commission will send letters to both parties and their counsel. Thank you for your patience.
Thank you, Grace.
So at this point, we would be looking for a motion to go into executive session, which cites all the proper parts of the statute.
So moved.
Thank you, Deb. Is there a second?
Second.
Okay, motion to go into executive session. Second, all those in favor?
Aye.
Okay, 3-0. Now I'm going to, Joan, we're going to lose you here because the rest of us are going to go into executive session. You're welcome to stay on this. I'm guessing our executive session won't be very long because everyone's hungry, but we will be back when we're done with the executive session. I'm going to try to move everyone into their break rooms. Hold on, breakout rooms. Here we go. Bloop. Did I forget to move myself? Join. Okay.
I was just on a call with Ally, so I have no idea what you guys were just talking about. Just to say, can you hear me, Amy?
Yes, sorry, I was muted. Sorry.
I just want you to know that when the vote to go into executive session was the last thing I heard.
That's okay.
Okay.
I got all that.
Yeah, we're out of it now, so we're good.
And there's nobody here that we need to account to, so I think we're done.
Well, except that we are still broadcasting and we weren't there, so we weren't out, so the public could see.
Okay, to the
I think we
public, yeah.
should revote.
I'm pretty sure the breakout room, yeah, took that out.
So
let's
I'm
move
just
that.
gonna,
Do we
I'd like
need
to
to
put
move?
it on the record. I would like it to be on the record in open session clearly that I'm gonna repeat, Ted had made a motion. I'm gonna ask you, Ted, to make this motion again to do the following: to not litigate E18-0431B Hodgkins versus Lambert, to authorize counsel to settle the Frodema case in litigation, and to authorize counsel to settle the Canecrest case in litigation.
It's so moved.
Thank you. And is there a second? Ed, you had seconded it before.
Second.
All those commissioners in favor, please indicate that. Thank you very much. I appreciate the formality. It's approved 3-0. And now we are good. And I thank you very much for your patience. Please go and eat lots of the food and we'll do better next time.
Thank you, Amy.
All right,
Thank
everybody be well.
Yes, stay safe out there.
Bye-bye.
Bye.
Bye.